Yes. 111. Yes.
Adjournment request, if any, from item number 1 to 25.
One here.
From item number 26 to 33.
The concern of the petitioner, my lord, I beg to mention item 33 on behalf of K. Gogol, my lord.
All right. Adjournment slip has been circulated. So also give a date.
19th May. Anyone for 31?
Further, adjournment slip has been circulated. Yes. This also.
June.
Item number 31.
9 June. From item number 34 to 39, adjournment request.
Wait, this is Lordship. Lordship for item number 34 to 36. Lordship.
34 to 36.
Yes, your Lordship. Matter may come up after BO vacation.
But why? You have not circulated in slip.
Lordship, yesterday we tried to contact Lordship. We had contacted actually to Mr. Harish Gupta. Who is,
Have you informed the other side?
Yes, your Lordship. We had informed today also. He had given the consent also, Lordship.
Okay. A prayer for adjournment has made on behalf of the respondent number, on behalf of respondents number 1 to 4.
Yes, your Lordship.
Respondents 1 to 4, after having obtained consent from the counsel for the appellant. So let all the 3 appeals be listed on, give a date after in April, May. This is with respect to tender. You have been ousted.
Yes, your Lordship.
The matter is, it has been handed over to other concessionaires. They have started their work.
Lordship.
So there is no urgency in the matter.
Yes.
21 May. 21/5.
Lordship, I beg to mention item number 38, adjournment slip has been
All right.
circulated.
All right.
26 May. Any other request?
My lords, I beg to mention 2 connected writ appeals for urgent listing, my lords. The matter pertains to an order passed under section 26(1) of the Competition Act. Now, there's a stay operating against me, because of which I cannot take forward the investigation, my lords.
That's not urgent. We will have it listed sometimes in April,
My lords,
the week between 6 to 8.
my lords, I'm being led by the learned ASG in the matter.
Right?
ASG, Mr. Venkatraman, my lords. So I would request if the matter can be listed for tomorrow, my lords.
It's not possible. You can have it on Friday. If he is to come from Delhi, or he will appear online,
BC, my lords.
VC. So I think let it remain on 6th of April.
Obliged, my lords.
Daily list for orders, item 1 to 23.
Pension, old pension, new pension. Okay, for what it is? ये जो हम segregate करने के लिए रहता है drop.
I think, my lord, these matters will have to be heard, my lord. The issue is, my lord, where the recruitment process started before 2005.
Now, why has it come for orders?
Of what?
Because of the review.
But this whole they are only obligation.
Oh.
That is why I.
So I think we will hear the review first.
Yes, yes.
On some other day.
Yeah.
We'll hear the review first and then we'll have it listed. Yes,
Yeah.
Mr. Bhattacharya, anything else that you want to
Yes, my
suggest?
lord, these matters have come in the order column for the reason, my lord, that these matters were, my lord, scattered. And this honorable court on the last occasion had expressed its mind, my lord, that let the matters be clubbed together and let the matters be listed in the cause list in distinct categories, my lord, with pertaining to the nature
right.
of appointment. That
All
is
right.
how, my lord, these matters have come. But I have, yes, classification. In the meantime, my lord, I have also prepared the updated list, my lord. We have already submitted, my lord. This is the updated list. If lordship may be pleased to peruse the list, my lord, the last serial number, my lord.
What do you mean by dropped?
But drop, my lord, that is a category of teachers, my lord, who were initially appointed. Their appointments were irregular, or my lord, in other words, they were found to be, my lord, illegal, and therefore they were dropped. Then again, my lord, they came to be appointed. Now they came to be appointed after the cutoff date of 1/2/2005.
So you've made three categories. One category would come under the dropped candidates.
teacher,
The other would be in excess of the,
excess.
and the third would be ad hoc,
Ad hoc, and fourth one will be, my lord, the
Operation
OBD.
Blackboard.
Operation Blackboard. That is
All
how,
right.
my lord, we have segregated. And my lord, so far as, my lord, serial
What
number
we do
20.
is, just a minute, Mr. Board, just let the registry know that all dropped matters should be listed in seriatim, thereafter, thereafter
think
excess,
we are
thereafter ad hoc,
including in
thereafter
drop.
OBD.
ये list में भी ये लोग कर दिया है।
No, listen, उसको ऐसे 1, 2 करके drop करिए. All dropped matters will be decided one. Let these cases be listed. Keep it after Bihu
Yes, ma'am.
on a hearing day.
Yes.
I think it should come up on 21st of April.
Can it be, my lord, in the second week of May, my lord, with all respect, my lord?
Yes.
Second week of May.
Subject to what they say.
Second week of.
Second week of May. All right, so on 12th of May.
I'm so deeply obliged. And lordship, only one aspect of the matter, my lord, that last item in the list, my lord, which lordship is taking up, for the item that 27, my lord, that matter is listed tomorrow before this honorable court.
Let it be listed. We are not
My-
disturbing it
my lord,
because it is
my
not
lord,
here.
my lord, my
And we will place it on the same date.
My lord, I'm so obliged.
Mr. Goswami, you have anything to
Well,
say?
no, my lord, I'm in item 23 in the category of excess appointees, my
All
lord.
right. So what we do is, we
My
have
lord.
asked them to categorize it, I mean, one
Yes,
after
my
the
lord,
other.
as your
So-
lordship pleases.
So
my lord.
once I take up the dropped matters, I deal with those writ petitions, those appeals.
The
Then
legal
same,
issue would be
one and the
common,
same.
my lord. The legal
Common, it's all
issue
right,
would be
it's all right,
common, my
but it will be easier for us to handle.
Yes, my lord. The ultimate issue is whether the Pension Act applies or the new contributory
Correct.
scheme. So that is a common issue applicable
all-
to all.
All right, let all these matters be listed for, these are not, these have not been admitted, no?
No,
No,
only
my lord.
notice were issued, my lord.
Let all these matters be listed under the appropriate heading on 12th of May for final determination.
Admission बोल देते नहीं तो फिर से ये orders में आएगा।
कुछ सही है ना, हाँ?
For admission. Along with the review petition. For admission along with the review petition, because with review, all this will come in order.
This is just an offshoot, my lord. This is just an offshoot,
Doesn't matter,
My
but
lord.
your rules say so.
my lord,
We would have even, I mean, in other jurisdictions, we hear review under admission.
my lord, my lord, my lord, my lord.
This is because of your peculiar rule of this High Court. Therefore, we are doing it. Let all these cases, including the review petition number 275 of 2025. All right.
I'm so obliged.
Deeply obliged. Deeply obliged.
I'll be going to-
Item 24.
Yeah.
Item 24.
Lord, in this case, the petitioners were praying for retrospective promotion. Now, my lord, earlier there was a judgment. Which your
Mr.
lordship-
Chaudhary, just give me 1 minute.
Yes.
पंखा चलाओ यार पंखा चलाओ स्टफ ही लगाओ I don't think AC उधर को पंखा चलाओ
Fine.
ask the lawyers if they want AC we can have it run
Yeah.
you want AC to be run no
I think
This is okay.
this is, I think, on.
This
but
is
stuff it.
except this.
All right.
No, gradually the humidity will start
Hmm.
because after the rain.
Mhm. उतना मत चलो उधर का लीजिए one is So why was it rejected?
Because, my lord, the earlier round of litigation, only 2 petitioners were there. However, based on that order, when the promotion order was issued, all were found eligible. And out of that list, my lord, only 2 were given the benefit, apparently because they earlier approached.
Yes, who appears for this date? Doesn't make sense, no?
Yes.
But we have some difficulty in accepting the correctness of that order, especially with respect to what does Rule 11(4)(c) of Assam Panchayat and Rural Development Officers Technical Service Rules say? The moment you attain that degree, you have to be promoted. I don't think this is the way it has to be interpreted.
Because dealt with in another round of litigation.
Women they claim that we should do
That may not be the issue here, but this is difficult because giving them notional, benefits from that date, from the date of judgment, it doesn't mean anything. Because what is the cutoff line? ये थोड़ी का होगा. ये नहीं का. Have we decided?
We have dealt with this issue, my lord. Now they will eat up that promotional quota, not beyond.
But then that's not the way, these rules are to be made and these rules are to be implemented. Unless the vacancy is notified merely because you acquired, suppose within 1 month, within 6 months or maybe 1 year, you acquire that degree from some fictitious source.
In the case which your lordship dealt with, there the issue was whether if one acquires during the.
No, that issue was unnecessarily raised. That we said that whenever. But this issue is something which is different. But the state has not questioned it. Mr. Porpujari, you have not questioned it. Otherwise, we would have had good occasion because this creates anomalies in interpretation of service jurisprudence. Compare it with the pan-India methods.
Especially when it comes to fixing seniority.
Exactly. Inter-C seniority, number 1, notional benefits from what date, what would be the cutoff date, why 6 months after the judgment. I mean, these are issues which remain unanswered. Now it becomes discretionary what the bench thinks fit. I mean, how do we fix 6 months? Why not 1 year?
Yes.
Why not 1 month only? There was a direction. No, these are
some rationale.
and the state never chose to appeal against that. So, but can you make a distinction now? Can you give it only for 2, denied for others? They all were appointed in the same category.
That judgment, that was a declaratory relief, my lord. That is not a judgment in personam.
That was a judgment in personam because there were 2 petitioners considered their cases in accordance with the rules. So it was in personam.
There was a declaration of law in that case also.
The declaration of law cannot be. No, this is no declaration of law.
Anyway,
I will not enter into all that. I agree for the reason, but it is very, very questionable.
Otherwise, the other aspect.
Very questionable. We can't possibly say where was the vacancy, how vacancy was notified, what is the rationale behind fixing 6 months, giving notional benefits. All this is
or in the rule, there should have been further clarification as to how to operate this.
Naturally. No SOP, no clarification in the rules. How do we do it?
It can still come up with some executive order.
They can, but to justify this order, बहुत मुश्किल है. I mean, at times the state also forces the court to pass an order which does not have the backing of the rationale of service jurisprudence. That is how you make it very, very, fragile for any person to enter into it. You add to the litigation unnecessarily. Fault lies with us also. We have left it open. 6 months. It's a common factor that if a judgment is passed, does it mean that the government must act within 6 months or after 6 months and no date? I mean, I don't understand the rationale. Anyway, you have done it for 2, you have to give it to them.
But my predicament is
predicament is all right, our predicament.
I am representing the finance department for respondent number 4. Here the employer is, my lord, the PNR, the Panchayat and Rural Development Department.
No, we see you, Mr. Porpujari, as the face of the state. Take up the brief, argue before us. There is no option left for you.
My lord,
He has dragged you against the wall. For the reason that you never challenged this, no?
Yeah, they are not. This is the decision.
You have not challenged the judgment dated 15/5/2017.
Yes.
If you have not done it, you have to give it to them.
Otherwise, my lord.
Take instruction, put a quietus to all this and come out with a SOP for future. If you don't want to make changes in the rules, that will be by virtue of amendment.
And learned friend can put up a note before the government.
That you will do. But here, since you have not challenged, you admit, we will dispose it off. Don't ask us to write a law which does not have the backing of rationale.
Yes, हम लोग ये करने से again it will be
I'm not happy with this. बताइए.
ये rule बोल के सीधा paragraph 4 में बोल दो.
Just read 11(4)(c), Mr. Chaudhary.
Yes, Lord. Yes, sir. At page 68, my lord. Notwithstanding anything contained herein before in this rule, subject to suitability, a junior engineer of Assam Panchayat and Rural Development Officers Technical Service, on his acquiring the academic qualification as prescribed for a direct recruit assistant engineer,
Against the
Shall
next
be
available
promoted.
vacancy. So how can it be read that the moment you acquire, I don't.
That's how easily has been.
I don't think so. Now, it depends on the state. We will not be able to ratify this, Mr. Chaudhary. You are to be promoted, no difficulty. We are only thinking of giving you notional benefits from that date.
Yes. Yes.
That the rules doesn't permit. Now it depends on them. They have given it to others. Therefore, you can talk of parity.
But I'm talking of only parity.
So,
I have brought two, three judgments on that also.
we are uncomfortable with this order.
We have brought 2-3 judgments also.
No, parity, once the original thing with which you are carrying parity is legally sustainable.
We'll go by
But
the rule.
that has attained finality.
That was a single thing.
तो फिर हम यही कहेंगे, that depends on them. Let them say. Mr.
It
Borpujari,
is a single thing, not a DV.
Otherwise,
That is not the only one.
my brother rightly points out, that's a single bench judgment.
Sorry, Milad.
That's a single bench judgment, not binding on us. We can redefine it.
Redefine.
Single
They
judgment.
try to redefine. And we think that's sense.
Chaudhary, why don't we look at it from a fresh point of view?
Only thing is,
We will not snatch it.
They've already acted upon the order.
We will not
Sorry.
snatch it from the two of them. We'll not snatch it from two of them. But for you, we will ask them to give you notional benefit from the time that the vacancy would have arisen.
Yes, yes.
Take a call. Have you followed?
Then we can interpret the rules.
Yes.
also.
Here what has happened, let me tell you in simple terms, these persons joined as junior engineers. The rule says that if they acquire the higher degree of AMIE, they will be promoted subject to the availability of the vacancy, and that would be treated as direct appointment. Now, nothing was being done. So some of them went before the court. Court said that consider their cases in accordance with the rules. Now, that also was a blanket kind of an order, no directions. It was just remitted to the state to decide whether they qualify for being promoted to the post of assistant engineers. The order was, nothing was happening, contempt petition was filed, and after contempt, you gave them promotion. You gave them promotion from a date. Now, that was only with respect to two of the engineers. Later, others also came, said that promotion has been given. So let us also have the notional benefit from the same date. That is either the date of passing of the judgment or 6 months thereafter.
yes.
Others have been given that notional benefit. How can you deny it? Only on the ground that the reviewing court says that it was original petitioners were only 2, therefore it is only for 2. Now, in that case, the only way out for these petitioners is to go to the courts again with a fresh writ petition.
Yes.
We may not question the correctness of the review order.
Yes.
But then we'll have to give them the passage to approach the court afresh on that ground.
Now, my lord, if in pursuance of
Now
this
take a call because vacancy must have arisen by that time.
Yes.
And this will be, the doctrine of relation back would be applied.
Yes.
Only thing
And
is, my lord,
it will relate back to the period when the vacancy arose and they had to be appointed.
Yes. Yes.
So whether that is within 6 months or later, I think it will fall to those 6 months only. So give that. Take that.
the thing is, my lord, the lordship should kindly have a look at page 77, my lord. That was the order by which all were promoted, but we were not given the retrospective promotion.
That's all right.
When we approached, my lord, then it was confined.
That's all right. Therefore, you have challenged
Yes,
the review
yes.
order. And review order, we may not question on the ground. I mean, review order cannot be questioned
Right.
in appeal. So, but we have to, as courts of law, we have to give you fresh passage. No, instead of
Right.
doing that and adding to the litigation, why can't you decide? Because suppose Mr. Chaudhary comes before another learned single judge saying that now after exhausting this review jurisdiction, we are here before you. Why no parity? The courts would be inclined to give it to him. So why take this circuitous path of going to the courts, having an order, burdening the court with another case, another judge writing something, waste of paper, no? Ultimately, they would.
Something like, my lord, joinder of causes of action, my lord. I'm so obliged.
The appellants, we have heard Mr. K.N. Chaudhary, learned senior advocate, for the, you want that the other officer to, the other law officer to take instructions in the matter.
Yes, my lord, because I am representing only.
That's all right. So we are, if he doesn't appear, we will look for you again.
Absolutely.
Take instructions and come back to us.
Lord,
We,
the law officer appeared on 4 or 5 occasions. Every time he says, I'll obtain instruction. On 2 or 3 occasions, he missed the matter. in
no, the
cause
difficulty
list.
with this court is that we see the all state advocates as the face of, if you are not there, we'll ask Mr. Mazumdar, we'll ask Mr. Khataniyar.
On 3 occasions, he missed the item, then 2 occasions.
I know.
And
And otherwise, advocate
take
generals
it.
and additional advocate generals, they
take it.
represent the state, face of the state. You can't throw that blame there, he's for that department or that department.
I will take it, my lord.
So, but take instructions. We are not deciding it today, but next week you must say it must go out of our list. Or we give them the passage, go before the single judge, but that is not proper.
In the Qualification of debate, and you are sitting after being defeated.
We have heard Mr. K.N. Chaudhary, learned senior advocate for the appellants. Mr. Bod Pujari, learned additional advocate general for the state.
I am not the additional AG, my lord. I am the standing counsel for finance department. That much, my lord.
maybe
You are additional AG,
No, my
no.
lord.
You are
I'm the
the
standing counsel.
wrong information. Standing counsel for so and so.
Offing.
Standing counsel so and so. The appellants were initially appointed as junior engineers in the Department of Panchayat and Rural Development. Over a period of time, they obtained the associate membership in civil engineering, which is commonly referred to as AMICE bracket I, bracket 1 or I, which is considered to be equivalent to a civil engineering degree. Based on this qualification, the appellants sought promotion to the post of assistant engineer under the prevailing service rules at that time. Namely, Rule 11 bracket 4 bracket closed, then bracket C of the Assam Panchayat and Rural Development Officers bracket technical bracket closed service rules of 2015. Demands were not met despite the appellants meeting the eligibility criteria. They filed writ petition before this court by WPC number 279 of 2015, seeking promotion on the basis of the degree obtained to the post of assistant engineer. A bench of this court by judgment dated 15/5/2017, directed the state respondents to examine the claim of the appellants for promotion to the post of assistant engineer under the above mentioned rules, under the above mentioned provision of the service rules of 2015. Later, after the filing of a contempt petition by the appellants, the appellants were promoted order dated 10/1/2020. Correct?
Yes.
By order dated 10/1/2020. Thereafter, some of the promoted assistant engineers filed a writ petition claiming benefits under Rule 11(4)(c) of the rules of 2015. Sought retrospective. They claimed claimed retrospective benefits under so-and-so rules. Their contention was that either they should be promoted from the date of the judgment in WPC number 279 of 2015 or within 6 months of that date. The High Court, after hearing the parties and taking into account the interest of justice and equity, granted the benefit of notional benefits to those applicants from a date of 6 months anterior to the judgment passed in 279 of 2015. That is from 15/11/2017. However, while doing so, this court had clarified that the benefits granted to those applicants would be notional only, meaning thereby that they would not be entitled to any back wages, and that the order would apply only to the petitioners of the earlier writ petition, as the order was in personam. The appellants herein, similarly situated to the applicant/petitioners, about which reference has been made in the preceding paragraph, sought similar benefits. That is for notional promotion from 15/11/2017. Primarily on the grounds of parity. This prayer was made in the review petition, review petition number so-and-so, which prayer was not acceded to on the ground that the original order was only with respect to a limited number of applicants, whereby it was made clear that such benefit would accrue to only the applicants. Mr. Chaudhary, learned senior advocate for the appellants herein, questioned the denial of parity by the learned review court. This court is presently and tentatively of the view that such a prayer ought not to have been made in a review petition. It could have been either a modification of the judgment, or the appellants ought to have preferred a fresh application seeking parity with respect to grant of notional benefits from 15, what was that date? From 15?
11/7.
11/17. Be that as it may, considering the fact that with one stroke of pen, the appellants along with the others were promoted to the higher post of assistant engineer on the strength of Rule 11(4)(c), there could not be any distinction between some of them and the appellants for the others to be given notional promotion from that particular date and denying the same benefits to the appellants. Mr. Borpujari, learned standing counsel finance, seeks some time to take instructions of the matter and get back to this court by the next date. Re-notify. We'll place it before Bihu. Or if you want after Bihu also we can see.
Can it be before Bihu also? I will make an.
You'll be able to do it. Or why not? No, we would put it only on a Thursday. Let it come on 21st of April.
21st, my lord, some difficulty, my lord. Any date thereafter, my lord.
23rd?
23rd,
23rd of it.
20.
Notionally मिलना है ना, notionally मिलना है तो फिर इनकी भी urgency नहीं है. You decide, take a call. I mean, we don't want to multiply litigation.
My lord, right.
And if that day, if we are not in that mood, we might say that this order needs a review,
That's it.
especially the notional benefit of it. I mean, you have chosen to sit tight over the matter. Now, we are not suggesting you anything. Please give them the benefits.
The rules are such, my lord.
Hmm?
Rules are such, my lord.
No, rules नहीं है ऐसा.
Vacancy.
Subject to vacancy, very clear. Why 6 months? Then the second argument,
Yes, yes.
the contention would be that this falls within that period.
Yes, I will get back, my lord.
And you could not have promoted them without vacancy.
Now, fact that you have.
It'll be assumed that it is against a vacancy. So when the vacancy arose, should have been the cutoff date
Yes, yes.
and not 6 months.
Yes.
It might coincide, we don't know. So instead of raking your brains for all this, you allow
Yes.
them the benefit that has given to others.
My lord.
Because it is notional.
It is notional only, I don't think.
No, sir, yes.
Please take
Yes,
instructions.
Yes.
We will.
I'm so deeply obliged, my lord.
Item 25. 25.
इतना ही था ना?
23.
इसका नाम क्या है? नीता वर्मा. Ms. Verma,
Yes, Lordship.
let it be posted after elections,
Right.
because that day the letter urged us. But practicality demands that, you see, there has been a cabinet decision. Good, bad, indifferent, that has not been challenged by you. Correct? So the matter must be placed before the Chief Minister for a review. We can suggest it, but the officers cannot say that it can't be placed, it can only go after elections. So that was not appropriate. Therefore, we have cautioned Mr. Khataniar not to pass on such letters to us. Keep it as instruction to you and tell us what is required to be told in a particular format. So I think the better option, Ms. Verma, would be that we see it after the elections. In that case, they are allowing vernacular, they are putting it on the website.
It is not functional till date, Lordship. This morning.
अब उसको तो करिए, Mr. Mazumdar.
This morning, so I checked up, Lordship. Lordship, I'll just take 1 minute. My thing is from 23.
But why don't you wear a band? This is not your personal case, no? You are appearing for.
All, Lordship.
Petitioner in person.
Person,
Oh, you are
Lordship.
petitioner in person.
Yes,
Okay.
Lord.
All right. I'm sorry. I thought you are representing a party.
If I am petitioner in person, this is the foundation we have where we take up these matters relating to.
But why is it not functional, Mr. Mazumdar?
No, I think that is not correct. My instruction is otherwise as such it is functioning.
She has checked up in the morning.
This-
No, well, it,
So we
I
checked
know
that.
that is not the issue before Lordship. If it is not functioning for the vernacular also, then we will take care of it. When the Lordship need to pass.
Please do it. Please do it and don't let the students miss out the opportunity
True,
for this academic session.
True, madam. And
Admission in this
so
session.
so far as the main issue is concerned, madam, in fact, personally, madam, I was sending about the brief yesterday. My AG is not appearing.
Take,
What I feel,
take
madam.
talk of the situation, talk to the director of
True.
secondary education. Hoga na? Talk to the director of secondary education.
At least this should be.
At least give a counsel to him or her, whoever he or she is, that this is not the way of, writing letters even to the lawyers.
That part I'll.
You please do that. And he should be careful. Yesterday also, he passed on a letter which which irked us beyond limits. But we don't want to make a chaotic situation here. I had a good mind. If my old habits had continued, I would have called the person saying that you have made yourself,
Lordship may
you have made yourself, amenable to a contempt jurisdiction of this court. You can't say this.
Lordship may.
We are asking them to consider they decide the law.
That this will not happen again.
You are that way, Mr. Khatniar. I must say you have been casual in these two instances. Pass on the letter to us. And don't expect us to just sit tight and not react to it. We understand the difficulties, especially in these times.
May I
Let it remain after. Let it come after.
I agree with Lordship. Lordship will just hear me for 1 minute, Lordship. From 23, when we filed the PIL, we had very simple 3 prayers. If Lordship comes to page 27 of the PIL, my second prayer was that the state should be issued directions under to upload a list of students admitted under 12(1)(c), Lordship. It is as per their OM, their activity calendar, which is annexed at page 43 here. And the second direction was to have a MIS or a website portal, which has not come up till today. And then the children should be allowed to access the website and continue with the admissions, which has again not been done.
Today, when you checked up the
Yes.
portal, there is no vacancy position stated.
Nothing, even the schools.
Not even the schools.
No, when the last direction. When
Instead of responding to this, they only talked about vernacular and English.
Even the schools, Lordship, it is there in their OM, the schools have to put up their vacancy position on their websites. Even the schools
How
are
many
not
schools
doing
are
it.
there on the portal? Tell us, Mr. Mazumdar.
Hello, may I just submit my.
Forget about any review of the cabinet decision. What is the number of schools which is listed? Mushkil hai.
No, it is there.
Mr. Mazumdar, please get briefed in the matter.
My lord.
We are posting it after view.
My lord.
But
May I just.
you would be making yourself amenable to contempt jurisdiction, contempt of the orders of the Supreme Court.
And the act itself is clear, in other words. Act itself is enacted for the purpose of providing free education, that is the elementary education.
Where is your letter
My lord.
mandating all schools to register on that portal? Show us that letter. ऐसे तो नहीं काम चलेगा ना. Then it's a hollow promise.
My lord, Lordship will fix a date after
We will
come up with all the.
We will fix a date, but then on that date also,
No.
Mr. Mazumdar, take the
May I-
responsibility. We are fixing a date.
May I just make one submission, ma'am? I have understood the problem here. So far as vernacular schools are concerned, there is no difficulty. It has been made operational.
You have to, yes.
They are only allegation as I find.
No, probably you have not understood. You have seen only one part of the complaint. Now, let me tell you, out of my memory, which I heard about a month back.
My lord.
Ms. Verma, you can correct me if we do. See, they say that under the RTE, a school, free education till standard 6
True, my lord.
to everybody. Now, how is that possible? It is possible only the schools register on that portal.
My lord.
Now, how will the schools register on the portal unless they are directed? So that direction was not there. Therefore, my minuscule number of schools
My lord.
thought it prudent to get on that portal. Now, unless you have sufficient number of schools bifurcated or segregated for each of the panchayat or district or whichever separating point you think it to be conducive for advancing the RT Act, that should be done. Now, suppose there are only 19 schools or 20 schools, or say some schools in one particular area, no school in the other area. Now, are you giving any benefit to those students? For whose benefit this is being done? For people who cannot afford private education. You expect somebody in Jorhat to come to Gauhati to take admission? In school.
Percentage hai, big percentage.
Subject to what?
Compulsion, there is a compulsion on the management of the school to give certain
25%.
25%.
Here the issue is 25% under
But
12
how many schools? Where is the list on the portal?
No list, Lordship, there is no account, no data has been submitted to the court till date. As per as our previous Lordship.
You can't have that piecemeal information, Mr. Khatniar. You're not serious about it. I'm
No, ma'am.
sorry.
Lordship,
Madam,
this
You're
has-
not serious about it. You
Yes.
take one information, you just answer one question. You don't come up with.
There has been various orders from this court, Lordship, that give us the data, place it in the court.
Madam,
But till-
possibly, madam, may I just make one submission? Possibly the whole issue in this PIL is the non-vernacular schools,
No,
particularly.
that's one of it.
No,
Not,
that is
No, no.
subsequently It is developed during website. This is
No,
not
no.
the issue.
This was picked up by the petitioners
My lord.
because of the wordings which you employed in that notification. It is not the main issue.
Main
The main issue is that whatever you claim to have done is only on paper. That's the issue.
Then, madam, I will, Lordship will give me this much
Please,
time and I'll
in the
come up.
meantime, take this time to at least have a letter of command issued to all the schools that they must register themselves. Otherwise, you don't have that grid to know of the information. Unless you have it on the grid, how will you enforce it? Now, first thing is that you must issue a directive that failing to do that would lead to cancellation of their registration or whatever. Correct?
Permission.
So they'll be forced to come on the grid. Then you'll have to tell them that please tell us the number of 25% of the vacancies which is available where we can pitch in.
No, sir, इसको ही upload में register होने से develop to say our 100 student 25 is available.
That's right. So once they register, they have to give their vacancy position, number of seats available for the current academic year or the next ensuing academic year. And then we will consider whether it is vernacular or English and the cabinet decision that has not been challenged. Anyway, we will see that. But vernacular or English,
At least let this
at least they should take admission. You must do something.
And in
You make a tall claim of giving education to all and it is not there. How many schools are there on the list?
more than 10,000 in the state of Assam.
No, no. How many schools are there on the portal? How many of them have registered?
Handful of schools, when I checked this.
Handful is a vague number. Tell us, you have checked it up today.
I didn't count, Lordship, it's in different districts, but in Kamrup we didn't
No, it
find.
is 45, we have the figure.
Only 45.
40.
Lordship, but.
Can you accommodate people in need of education in 45 schools?
Well, let me have.
Lordship, may I submit, Lordship?
At least vernacular admission to this session में होना चाहिए ना.
And how about continuing with how about giving admission to students even in vernacular medium
Within this
in
session.
this session?
Session, session.
How many have applied? How many have you given? How many have you
It
projected?
will start from the month of April, my lord, since the
Then-
lordship is taking immediately after the vacation, my lord. So I will take care that admission takes place.
I don't take it as an adversarial litigation.
True, my lord.
It is your,
merely implementation of the act itself.
it is not adversarial.
No, my lord.
Nobody is claiming that I wanted admission, I did not get admission, nothing of that kind.
And I have seen the guidelines, my lord. So far as the guidelines is concerned, it's very clear. Reimbursement is not the entire amount. I was initially thinking that in a private school like we have now some private schools where the monthly fee will be in the order of maybe
Well,
1 lakh.
we
So
can't.
far as reimbursement is concerned, it is only the pre-child expenditure which will be
We
determined.
are, don't misunderstand us,
Madam.
don't misjudge us that we are not saying that you're not interested.
Madam.
But the steps that you have taken is very deficient. Very deficient.
That I'll see. I'll see to it, man.
Talk to the director today. I mean, today means within a
Yes,
couple of days.
at the
Get back to us.
So that by the next date, madam, I come up with a formal.
Mr. Dilip Mazumdar. Dilip Mazumdar.
Sir, इसको
Lordship.
again. ये petitioner update क्या कर रहे हैं only for this भरने के लिए application से कुछ नहीं कर ना ना कुछ नहीं भरने का मैं छोटी की बात लगा था अभी जैसे 22nd नहीं करेगा ना कुछ नहीं करेगा अननेसेसरी हमारा ब्लैंक चला गया
Lordship, by order dated 29/8/2025, this court had very clearly directed the state lordship to take concrete steps and to ensure registration of all schools on the concerned
This court had
portal
passed that
for
order.
implementation. There have been orders of this court, repeated orders, Lordship. And the Lordship. the
Mr.
orders that-
Mr. Mazumdar, you are giving space to her to argue that the Director of Secondary Education is in contempt of this court.
Since your lordship is,
We would not shy away from issuing a contempt
No.
notice to him.
lordship
These
is
are
given-
directions, these are not being,
Lordship,
these are no pious wishes of the court. We have given you enough time. Perhaps Mr. Khatnia did not understand the importance of it. He thought it is just an empty direction. Tell us what grounds do you have to stand? आपने कुछ भी नहीं किया है.
some proactive steps will have to be. I have understood.
Exactly.
Don't
happened.
we let him
Yes.
take stock of the situation. We will take down. Mr. Dilip Mazumdar, Dilip Ghosh लिखता है ना? Dilip Mazumdar. Mr. Dilip Mazumdar, learned Additional Advocate General, submits that he shall look into the matter, take stock of the situation, and would get back to this court with concrete information regarding mandate to the schools to register themselves, to register the institutions on the portal and disclose the number of seats which could be utilized by the state for giving free education to children till standard 6. He would also take information whether such privilege is to be extended only, such admission is to be ensured only, privilege, such admission is only in vernacular medium schools or English medium schools also. Let this matter come up for consideration on immediately after BU, but don't forget during festivities.
No,
That this has to be done, and we will look for you only. Therefore, I have dictated
we'll
you.
start the process before the bihu starts.
All right. We will keep it on 23rd of April.
True.
Also go through order at the 29/8.
My lord,
29/8/2025.
Our orders.
Our
my
order.
lord, I will go through all the orders. My lordship.
I've been
sometime-
giving a long rope.
My lord, I have understood.
That don't test us.
I have
No?
seen the order, my lord.
Item 26 to 29.
ऐसा सच है, ऐसा भी नहीं है।
What's the meaning?
My lord, we have assailed the virus of a rules which have been framed basically to perpetuate an illegally. Lord, some 11,000 and odd appointments were made without advertisement. Now they would like to regularize those appointments by amendment of the rules. And that is what is under challenge. It's a blatant case. And regarding
Let us
those
see
11
let us see who appears for the state.
Yes, yes.
Are you ready? He is challenging the correctness, the validity of the rules.
You will appeal.
The rules
2000,
is at page 97.
just a minute. Assam Elementary Education Provincialization 4th Amendment Rules of 2024. He has
Yes.
challenged it. He says it's a sham regularization.
Yes, Madam. Learned AZ will appear in this matter, Madam.
The Education Department को थोड़ा सा करना होगा नहीं चाहिए।
Promotion ने बोला था, no, you can appeal this department in a sum. Can pay. You can try to.
All right, we'll keep it after. You have challenged the rules. So the state has to be heard. We will select it.
It's an open and shut anyway, my lord.
No, but open and shut, this is a legislation which is under challenge. It's a legislation which is under challenge.
Of course.
Hear. See, by virtue of these rules, they would allow a special recruitment drive to convert contractual teachers into regular service, but only against personal posts. And what does it mean?
That means below the moment they retire, that post will stand as a
Vanish.
list.
And without any past service, no financial benefits or no seniority. That is your concern. ठीक है, आपको अभी तो salary मिलेगी.
No, my lord. All that we are saying, my lord, those illegal appointments under challenge in WPC.
That's a different
number
issue, Mr.
3807 of
Chaudhary.
19.
That's a different issue.
Yes.
Presently you're challenging the
Presently,
amendment
our-
rules of 2024
Yes. How can
on
we
the
not-
ground.
How can 11,000 appointment be regularized by framing a rule when those appointments were without advertisement?
That is a question which
Ah.
they are
Others-
supposed to answer. That's a question which you're supposed to answer. Now, therefore, the amendment rules.
Yes,
So it overreaches that mandate of the court
yes.
It
that
is-
illegal appointment is void ab initio.
It is incorrect, my lord. It was, appointment was made.
Without this amendment, you could have said
Percentage-
recruitment drive, and you find out whoever would produce certificate of his teaching experience would be entitled to participate in that recruitment process. There'll be a written test and an interview. Basic qualification would be this. So
They were appointed person to valid selection process, my lord.
No,
Though contractual,
he is questioning the validity of the rules of 2024.
Yes.
Unless you make a statement that all those 11,000 appointments are valid appointments.
yes, my lord.
The moment you say that, you will have to regularize them. Then this special drive is meaningless. What are you're not understanding where he is hitting. Try, don't fall in that trap. No. You have to defend the state. You're falling in the trap of Mr. Chaudhary. Courts are conscious, not Mr. Chaudhary only, the lawyers for the appellants and petitioners. Now he wants you to say that, well, this is wrong. This challenge is wrong. This amendment rules is only for facilitating the appointment process. So all 11,000, if you make that a statement, then this is unnecessary. That is what he is formulating. I think I'm correct in assessing what you have said. बताइए इसमें कैसे करेंगे आप? What answer are you making? Then what drive? If all those 11,000 persons have been selected through proper channel, then another rule, another law will apply. Why amendment? Why the fresh process?
Because, my lord, in fact,
नहीं है ऐसे don't ad hoc answers are not required. That's not advisable also. Don't give those ad hoc answers अभी आपके दिमाग में जो आ रहा है, you are answering. That's the thought has to. He will question that what was the rationale of coming up with these rules? That means that you want to filter persons who have been rightly appointed, but they are only temporary, they are only ad hoc or temporary, they are not regular, through proper channel. So we'll further put them to scrutiny. Then those people will come again and they'll say that why are we not being given the advantage of our teaching experience? And with this rule also, you make it only personal. So where was the necessity of these amendment in the rules of 2024 when you're deciding to give it across the board and making it only the personal post? The posts will vanish. Now, whether you can be permitted to do that, those are the questions which perhaps he would raise. आप ऐसे इसको ऐसे नहीं आंसर करें. Mr. Khatnia, do some homework.
yes, my lord.
Take instructions and just don't depend on what your officers say. Apply your mind, vet it, and then come back to us. It's not so easy.
Understood, my lord.
We can dispose it off by saying that this is just for facilitating the entire process. All 11,000 of my teachers are properly appointed ad hoc teachers. So in view of Jago and the other case, we are giving them appointment. So therefore, this amendment rule should not be questioned. If you mean it, say that, he will withdraw. You don't mean that. Then why are you making it personal post? Why are you not giving the advantage?
It is the object, then he'll get everything.
And if you want to make them regular because they are through a proper channel, but only ad hoc, then why are you making it personal without any seniority? Anyway, समझा ही नहीं ना. They're trying to understand where you're being hit.
Yes, ma'am.
There must be some rationale, some logic why you have come with this. Without the amendment, you could have done that if you're interested. देखते हैं. Let's see what you do. Mr.
28
Petitioner,
April.
Leonard,
28-4.
you're standing counsel.
In fact, we have filed our affidavit also, my lord. In one
देखो
of,
हम लोग एफिडेविट पर
one of
डिसाइड
the
करते
matters,
हैं
मतलब-
क्या लिखा है एफिडेविट में. नहीं समझा, फिर कहता है एफिडेविट.
Mr. Khatnaniar, are you going to the affidavit and decide today or
No,
do
madam,
you want?
no,
Then
I-
forget
I
about the
just-
affidavit. Why should you look it?
Thus,
क्या आप एफिडेविट कहे होंगे? I can presume. Started saying it from your affidavit.
no, Mr. Learned as you will appear, thus I am informing that in one of the matter, my lord, we have filed our affidavit.
Mr. Khatnaniar, learned standing counsel or the education department submits that in this matter, the state would be represented by the learned AG, who is not present today. Let these matters come up for consideration on
28-4.
on 14th of May,
In admission column.
under the appropriate heading.
Obliged.
I'll file another affidavit, don't worry. Then, no, we are putting it on 21st of May because there are 40 matters on that day. We'll not be able to. 21st of May.
Item 30.
Either which matter relates to the assigned
Yes, Mr. Bhatti.
My lord, I have challenged by this petition the validity of the order which has been passed by the PIPA.
Have we passed some order?
To make the payment of 35%, my lord,
Just a minute.
at page 9.
Just a minute, Mr. Bhatti. We are looking at our order of 5th of September 2025. Yes.
My lord, the order which is.
The only difficulty, Mr. Bhatti, here is that we are in possession of judgments, and we remember those judgments which says that it has to be given a meaningful interpretation, word any order,
Yes,
sunshine case.
yes.
But then in so many cases, they have said that it cannot be reduced to nil. This is one hurdle which you'll have to make us cross. Number two is that ultimately it will lead to the financial liability. Because you say that there is no equitable mortgage, and this is a very clever stratagem. Without the equitable mortgage, you would not have got the bank huge amount as loan. You're trying to run away or delay the litigation. This could be one presumption against you. Because you have obtained the loan. Do you deny it?
Yes.
You don't deny it.
Yes.
If you don't deny it, then going up the garden path, that original title deed is with you is not going to give you any benefit. The fact is that if there is no denial, there is no proof of the loan having been received by you, we will not only go by the idea that it was no equitable mortgage was created. We will be deeming it to be an equitable mortgage. In that case, this ground would be in the process of determining the financial liability. Therefore, this pre-deposit requirement under 18A cannot be reduced to nil. We can only say that consider it from 35 to 25%. That's all.
So only one thing.
I think we have made our views clear here.
Yes.
Because we are not, see, this is a writ petition. Equitable relief is given to persons who come with clean hands. You take loan from a bank and you say that without mortgage, they have given us loans. And you want nil value to challenge an order. ये मैं लिखाऊंगा तो you lose out on your basic rights. If we dictate this while dismissing your petition, you lose out on your basic premise to question it. The better course is that you pay 35% of the amount in question, which shall be offset when it is found that the loan has turned bad, and then have it contested later. Today, as on date, we take it as a strategy to delay the recovery process. अब ये लिखा हूं तो आप, Mr. Bhatti, would it be beneficial for you?
My lord, only one.
We will agree with your submissions that a meaningful interpretation is to be given to any order appearing in 18A. Correct. To that extent, we will be following the line of the judgment of Honorable Justice Pardiwala in Sunshine. Correct. But we will say factually that you have taken huge amount as loan. You don't want to pay it back.
Definitely, my lord, so far the amount.
अब बोलिए, let us not argue one thing further. You are ready for this? We will say that no, we are not going to interfere. Sunshine, we will refer, and we will say that prima facie it appears to us that equitable relief cannot be granted to you.
My lord, only one thing. I point
Two options. This is a view
Yes.
and other is 35%, and we'll send you back. A or B.
आप ऐसे तो delay करेंगे process को. We will not leave the bank high and dry. The whole purpose of SARFAESI would be defeated. Otherwise, we decide that you have obtained the loan. No difficulty in this factual position. You don't. It has turned bad. Now, the bank wants to claw it back from you. You are raising a technical objection. Is it for this?
My lord, in that.
And then why do we reduce? Why do we ask?
Yes.
Why do we enter into this?
My lord,
बोलिए, हम
it
तुरंत
may
खत्म
be reduced to 10%, my lord.
No.
हम 35 से कम 1 पैसे नहीं करेंगे. This is the domain of the DRAT and DRT. Number one, that decision has to be there. Plus, this is a financial liability.
Yes, that is, I admit, my lord, that I have.
No, we will record that. We will say that under 226 we don't want to give this relief. Clear. We find this to be a dishonest, not a very honest way of your client to approach the court. We are clear on law, and we hope we are clear on facts.
Yes, my lord, only one thing.
Nothing. We have 35% you must pay. They have reduced it from 50% to 35%. We don't wish to interfere, and this is the reason. I caution you beforehand. क्या कहते हैं उसको? Before that, before conceding or arguing, you know your weak point. मैं यही लिखाऊंगा, sunshine लिखाऊंगा. The statutory provision I will dictate, and I shall say that we are not interfering for this reason. He has taken the loan, he doesn't want to pay.
Yes, so far the liability is.
You have to take a call. Otherwise we dismiss this petition after recording the law, or you withdraw, go pay, contest. Because we will be saying, while we dismiss your petition, we'll be saying that this appears to us to be a clever stratagem to escape payment and delay the whole process of recovery. इसके बाद आपको वहां भी नहीं सुनेगा.
Let me open the instruction.
नहीं, अब इसको आज, today you take telephonic instruction, we'll close it today.
My lord,
Don't ask, we are not asking you to withdraw. Mr. Bhatti, don't misunderstand us.
Yeah.
We are not asking you to withdraw. मेरे यहाँ एक कहावत ये है ना कि Chobe is a title. Chobe means who knows 4 Vedas.
Yes.
So he wanted to become a Chabbe. I mean, 6 Vedas he knows. And ultimately he became Dube. तो मैं नहीं करना चाहता आपके साथ.
Yes, my lord, I
वो मैं नहीं, I don't want to put you to that trouble because
it was a simple act.
आप take instructions, take telephonic instructions कि the court is very much against it. And law the court appreciates, but then you should not press this. Otherwise, हमें लिखाना पड़ेगा. To dismiss an equitable relief, we have to say why we are not doing it. Or let us do it in such a way that it doesn't harm you. We'll say that it is open. Or yes, Mr. आपकी एफर्ट तो हम लोग लगा दिया बैंक के पास.
Yes.
हाँ.
Trivedi, Trivedi and Chaturvedi.
The order under challenge in the present writ petition is dated 7/8/2025, passed by the Debt Recovery Tribunal. ऐसा नहीं, ऐसा लिखो. The petitioner was granted a loan of rupees 1,46,76,3 as a term loan to be repaid in equal monthly installments of rupees 1,66,807. The contention of the petitioner is that though the loan was availed by the petitioner, but there was no creation of an equitable mortgage of any particular immovable property. This contention was repelled by the bank, claiming that the original title deed of the immovable property lies with the bank. Stop. While pursuing his case before the DRT, the petitioner sought leave of the court, sought an order from the tribunal for forensic examination of the title deed which the bank claims to be in possession of, and the petitioner contends that the original title deed of the property in question is with him. This was denied by the tribunal, considering it to be unnecessary. First up, such denial was challenged by the petitioner before the appellate tribunal, which mandated that a reduced amount of 30% of the liability of the amount in question must be made as by way of pre-deposit for the appeal to be entertained. First up, the petitioner has questioned the pre-deposit requirement of 35% of the amount in dispute, of the amount claimed by the bank, for the reason that the order challenged before the appellate tribunal does not determine any financial liability. It was only a denial of the request made by the petitioner to have the title deed, the property said to have been mortgaged, be subjected to forensic examination for the reason of the petitioner being in possession of the original title deed. Section 18 of the Securitization and Section 18 of the SARFAESI Act of 2002 provides that an appeal against an order passed by the Debt Recovery Tribunal could be filed before the Appellate Tribunal within 30 days from the date of receipt of the order of DRT, but only on the deposit of 50% of the amount of debt due. वहाँ जो हम question amount लिखते हैं ना, amount of debt due to the borrower as claimed by the secured creditors or determined by the DRT, whichever is less. Proviso to Section 18 gives latitude to the tribunal, to the appellate tribunal, to reduce the amount to 25%, but only for the reasons to be recorded in writing. Mr. Bhatti, learned advocate for the petitioner, contends that the order challenged before the appellate tribunal does not come within the purview of any order within courts, as it is not against any quantification of the debt amount or creating any financial liability with respect to the loan taken by the petitioner. Relying on a judgment of Supreme Court in MS Sunshine Builders and Developers versus HDFC Bank Limited through the branch manager and others, 2025, Live Law, bracket SC, page 459, the petitioner contends that without a meaningful interpretation of the word within quotes any order, the right to appeal against an order which aggrieves the petitioner would stand negated. Stop. Any or every order that may be passed by DRT, if sought to be challenged, Mr. Bhatti contends, ought not to be made subject to any pre-deposit. Stop. A bare perusal of Section 18 and its proviso would indicate that such condition is mandatory and it could be reduced from 50% of the amount due to 25% by the appellate tribunal by recording its reasons we don't find anything in the order passed by the DRT or the DRAT which would reflect any hardship faced by the petitioner/borrower. The law with regard to pre-deposit under proviso under Section 18 of the SARFAESI Act 2012 is very clear. And since pre-deposit is mandatory, it cannot be made nil by the appellate authority. Stop. The High Court ought not to normally interfere with such decision of the tribunal or the appellate tribunal, such decision of the appellate tribunal, unless shown that such order by the appellate tribunal has been passed mechanically or without considering the hardships faced by a borrower applicant. There is yet another aspect to the matter which must be gone into. The effort of the petitioner appears to be to dispute the creation of an equitable mortgage with the ultimate aim of not paying back the loan, which admittedly has been availed of by the petitioner. This could very well be considered, as contended by the bank, /secured creditor /creditor to be a clever stratagem to delay the clawing back of the money belonging to the creditor. Under such circumstances, Mr. Nandi, learned advocate appearing for the respondent bank, submits that equitable relief of any direction for lessening the pre-deposit amount or making it nil ought not to be given to the petitioner. We fully endorse such submission, especially in view of the fact that there is no dispute with regard to loan amount having been availed of, loan amount having been transferred, loan amount having been availed of by the petitioner, and the loan having become bad and declared NPA. Under such circumstances, especially of the petitioner not showing any reason for hardship, any reason or hardship, paying the pre-deposit of 35%, bracket, amount reduced from 50% by the appellate tribunal itself. How have I begun this line, Vijay? And not finding that such order was passed by the appellate tribunal mechanically, we would not interfere with such decision making of the appellate tribunal. This is not going against you. Otherwise, we would have said that there's a dishonest way of keeping back the money. For the aforenoted reason, we dismiss this.
Item 37.
What has happened is I represent the private respondent. Now the issue, the impute issue was the selection of the post of principal in Kukrajar College. So eventually I was appointed, the writ appeal was filed, and Kukrajar College has now turned to a university. The principal became the first registrar. Recently, my lord, there has been some development and I was removed from that particular post. And again, I was placed as an associate professor in the Department of Mathematics in that particular university. So I don't think anything survives in the matter.
Only thing is, Milord, I was the second nominee. Therefore, the authority will take an appropriate call.
No, there is no post of principal, isn't it?
University ho gaya.
Only university.
Oh, so now it is converted to
University.
I think it has
He
lost
is
its-
back to associate professor.
the learned counsel for the parties.
Sir, now the lien is also
The
not
learned
there.
counsel for the parties submit that in view of the Kokrajhar College having been upgraded to the status of a university, the whole dispute has become infructuous. As such, this appeal is dismissed as having become infructuous.
Keep your.
The नाम लिख लीजिएगा दोनों Give your appearance slip, Mr.
39.
ठीक है क्या है ये सारे जो
20, item number 29.
39 Please announce them.
NIOS. Ah, yes, yes. Yes,
My
you have to
part,
take instructions in the matter.
my part was over, my lord. The government was to take the. instruction.
Government part was very clear that they will scrutinize. You don't have the papers, they have the papers. That's your stand.
Yes.
So they will scrutinize on the basis of documents they have.
I'll just clarify two things, my lord. Yes.
And we have imposed another condition on the state
Yes.
that while rejecting, or if they allow your claim, so far so good, while they reject your claim, they would state the reason why they are rejecting.
Yes.
Correct?
Now, my lord, now there is an element of verification is involved. Before any appointment, normally it's an power which is inherent in the authority. But in the facts of this case, whether that is the situation, that on one aspect, my lord, people also should kindly have.
No, you're going on merits then. The necessity of introducing this third level filter and then asking you, see, they cannot, they have some grounds to say that many people, many institutions, many authorities in the education department, they were acting in cahoots with each other and they went for this kind of certification.
That is not the stand here.
No, that is not, that may not be your stand, but
No,
they.
that is not the stand of the state.
No, they say that they have got the entire thing. It is very difficult to decide only on the certificate of 18 months of that diploma.
What I'm saying is, if a lordship, can you give me 5 minutes time?
Yes.
If a lordship should kindly have page number 2 of the compilation, just to refresh the memory. When, my lord, we were admitted to the force.
But before that, if I forget, Mr. Advocate General, I have adjourned 2 matters of the education department for your interference. It has got nothing to do with this case. One, right to education. No. I have entrusted that responsibility to Mr. Mazumdar because it is, I don't consider it to be adversarial. Something has to be done in that regard. And there is another contractual appointment teachers amendment rules of 2024. That we have fixed a date sometimes in May. Just be conscious of it
21,
because these are
21st May.
21st of May. After, I mean, we are not placing these matters before election or in the aftermath of elections for giving you time to understand.
In this case, Lordship, before the other side starts, if they have reservations, what concession I have given, I am still sticking to my concession. If they want to argue further, then Lordship may be pleased to hear the whole case on merit and Lordship may be pleased to decide the matter on merit.
Mr. Chaudhary.
Let it be hard on merit. I'm still taking that stand that we are okay. Whatever concession we have given.
I think it is better, Mr. Chaudhary. This is, take a call. You are the advisor of your clients.
No, Lord, if your lordship should kindly come to page 96 of the compilation.
Compilation here, wala?
Now, these are the documents which they are insisting upon. Page 96 of the compilation.
Yes. That's
Lord, appointment order we have given.
No, you only say that item number B, C and F you cannot do.
F we cannot, my lord.
B, C and F. So they will check up.
Yes, F we cannot.
And they will tell you.
Yes. My lord, some of them have B, some of them have C.
No, wait.
Only
whatever document you have given, all right.
Yes.
If you are not in possession of such document, the state will see its own archives, check up, and will respond to you.
Yes.
That for this reason we find your candidature to be.
And in doing so, my lord, in doing so, they will have due regard to the notification dated 3rd of August 2017, especially clause, my lord, 6 to 11.
3rd of August?
Yes.
What is that?
3rd of page, compilation page 2, my lord, page 1. Please come to page 2, my lord.
इसमें हम नहीं जा सकते जैसे लोगों को बोलेंगे
7 to 11, my lord.
there is a distinction
They
between
will have due regard to this.
admission into the
Okay,
Yes.
they have the database of
Yes,
such
yes.
teachers, 7 to 11.
Yes.
no no वो तरह मतलब वापस वो admission
They will have due regard to that.
How with due regard?
Yes.
Now, suppose it is found that you were not entitled, you were not,
registration
you are not
I can't
entitled
make
for
an
registration.
assumption, Lord, in an appropriate case, supposing I do not even exist, then certainly they have a right to inquire.
Yes.
Only thing is, my lord, the manner in which these are sought to be, it is a onerous, not in the context of the case.
No, if they ask you, not now with this concession of the state, I don't think it becomes onerous. Whatever you have, you give it. We'll further verify from the state, but on these parameters, we'll test your bona fides.
Okay.
Correct. Mr. Kalra, you have to say anything?
I have to say only one thing because they have different categories of persons in the writ appeal.
We club it all. You decide. See, you have asked.
We will insist of all the documents which is part of that notification, which is challenged. If it is available with us, we'll look for take it from our archive. If it is not available, then what will be our option?
No, you'll say
They
that
will say they will not give.
then you will have to tell them that look, see, this is for further
Other than
litigation.
you guys will give.
Huh?
Other than you guys code, whatever documents.
Whatever
you ask-
documents they have, you ask for them.
Yes, yes.
They will give. Whatever they don't have, you find out from your records.
Yes, yes.
If you find that the records are just a minute, if you find that the records are non-existent, I mean, there's nothing. There'll be a presumption that they were not there.
The issue will be like this. They will not have some documents here. And they will also not have, the school will not have the UDICE also. So we'll have to reject it. That submission may be recorded. Because
we will
otherwise
say-
they will come with all this from 5 or 6 to 11, all these things. It is very
No.
vague. Yeah.
We don't say that you have to reject it. You will say that you will find out from your records because you have to maintain the database. If at all it is not there, then probably you cannot rely on something in thin air
Yes.
to decide their bona fides. I mean, the
Now, suppose-
intention should not be to reject, but only.
Yeah, our intention today, I have just verified, around 400 had applied and about 190 have already joined. So they have all the 6 documents. 190 out of about 50% who have applied. So that means they are clean. They have no difficulty with it. Now,
So what
one of the primary document is
that's
that
all right. That's
appointment
all.
order.
We don't get into this argument. We will say that we sustain the judgment of the learned single judge
Yes.
with the caveat that whatever documents the appellants have, they will furnish out of the documents which is demanded for further filter. If not, the state will first try to find out whether they have such information in their records. If there is nothing on record,
I fully agree to this order.
Kalla.
I just need 3 minutes by clock, my lord. There's something that I want to point out. On the last occasion, I had informed that after passing of the impugned order of the learned single judge, the Honorable Supreme Court has passed an order for a different state, Odisha and Telangana, and has given that finding that indisputably those petitioners were in service. Now, on what basis was it given? I also showed the document last time. It was on the basis of one experience certificate. This experience certificate is not something that I chose or the state chose. This is because the MHRD at the time of admission said that only one document is sufficient. Now, my lord, we have procured that review petition order. So against that, a review petition was also filed by state of Telangana on various grounds. That review petition order we have procured. The review petition order we are just tendering, my lord, my learned counsel, my colleague is just tendering, my lord. There, the review petition has been dismissed. So the challenge, I'm sorry. The challenge.
If you want to bring that on account, file your affidavit. Otherwise,
we will file the
file your affidavit. Otherwise, you'll again make it a contentious. Our interest. File an affidavit. We will record the submission of Mr. AG.
My lord, yes, just 1 more minute, my lord. I just want to complete, just for my satisfaction, please permit me, my lord. That is point number 1. Point number 2, my lord, after the review petition being dismissed, there was a contempt pending in the Supreme Court that why the appointments are not being given. 2 days back, an order has been passed by the Supreme Court in the contempt, saying that if you don't give the appointments by tomorrow on the basis of one document, forget all others. Then,
Mr. Kalra, you are saying something about facts of which we are not aware of. You
No.
put it on
Yes,
record. We are
I
not
will-
doing anything.
I will definitely put it. All that I'm trying to say is this, my lord, that for today, my lord, kindly do not consider, my lord, please consider my submission, my lord, that please consider
We are
not
giving you-
pass.
We
Yes,
are
yes.
giving, we are
But-
giving you opportunity. So far as Mr. Chaudhary is concerned, is clear. The learned AG is absolutely clear. He gives this concession today that they will try to find out those documents from there. They will further confirm. The purpose is not to shut you out. The purpose is to only allow persons who are rightly certified for undergoing a course of 18 months instead of kitna hai? 2
24
years.
months. 24 months.
24 months.
That is point number
They
one.
only should be appointed. That he says we go by it, we don't change the order. But now that you say that once it was decided, it has to be done, we will see the facts. Now, if you, just a minute, Mr. Kalra.
My lord.
If you give us only the orders, perhaps we will not be satisfied. Then we reject it. You otherwise
Today.
also the facts are different. Here it
My
is
lord,
something
I will
different.
convince that the
So
facts are.
give us the petition, the facts and everything on affidavit. If at all there is some comparison, we will go by
Today
what
we
the
will-
Supreme Court says.
Right.
Otherwise not.
By end of today, we will file it. There is also a second argument. Kindly consider this. 60 seconds, not more than that. In 2017, my lord, when the admissions were taken by petitioners like me as well as Mr. Chaudhary's clients, my lord, that time the state took one document from us. Just consider this submission for a minute. On the basis of the document, the state's nodal officer gave the names to NIOS. Now, NIOS in their affidavit has said before this court that the names of persons that were given by state are available with the state. So today, my lord, just let me complete for a minute. Just let me. So therefore, the information that will be available with the state from 2017 till 26 will be at best the names forwarded by the nodal officer as on 2017. Because those documents which are being sought today were not asked at that time. If those documents were not asked at that time, there was no opportunity for me to give it. The only document that was asked for at that time was an experience certificate, which I gave. So therefore, today asking the state to verify the archive to find those documents may be an exercise in futile for this reason that I did not give it at that time because it was not required. The second part of my argument is that if they have to verify, the nodal officer has to simply produce the names that were forwarded in 2017, I rest my case. Let them at least produce the names that they had given to NIOS in 2017 because that is what their duty was. And the last...
Mr. Kalra, go by the experience of the court. Don't insist for it. We can write it.
Lordship,
Now you would be facing prosecution. In all its probability, perhaps your clients, instead of getting a job, they will be facing prosecution along with those school principals. You want that, we can initiate an inquiry.
In fact, I will more than welcome Lordship because
That
from
the
the
state wants it. If you put it on record, we will say.
So very well. Can I just do it one?
in the documents itself, there are 3 different stands. They themselves were saying we are not.
Yes,
working.
you leave it to the state filter. They will do it and they'll tell you the reason why you will get an opportunity. But they will try to accommodate. See, you have spent time on 18 months training. They'll not like, normally the state would not be against Mr. Kalra or Mr. Chaudhary otherwise.
Sure.
They don't know who you are. They'll check up the records. They will find if it is worth accepting. They are short of teachers. They want. Let them decide. But a non-bona fide person.
We are not. Make it clear, we're not running.
वो सब Supreme Court आपको देना हो दे दीजिए. But we are very clear in our minds.
There's an arguendo, my lord, and I will put that on affidavit. I just need 1 day's time. Today evening, I'll file it. My lord may have it out any time after that. But just as an arguendo, just consider this last submission. 10 seconds.
The last week of April.
10 seconds on this.
All right.
Just as an arguendo, one last submission I wanted to make.
They filed an IA. We are not adopting that.
Mr. Chaudhary is not adopting that argument, but
Very
we'll
well.
decide it together.
Very well. Just as an arguendo.
How many
They filed an IA in our case.
Okay, that is what I'm saying. He's an
So we are not adopting that.
तभी आने दो. Even then, let them. We have not passed any order. The order is against them. Let them. You file it end of April.
Very well. End of April. Just 10 more seconds I was taking, my lord. Not more than that. Just 10 seconds by clock.
No, उस समय करिएगा ना. No more.
Very well. End of April, my lord, we'll put that affidavit on it. Very well.
Can we just find out his case and dispose it off?
We were agreeable to that order, Milord.
He is agreeable.
Because basically it's our appeal where he has filed an IA. Let him file an independent application.
You file an independent application, you get an opportunity.
Let him file an independent appeal, Milord, or a petition, whatever it is.
You file an independent, we give you the liberty.
my lord, then limitation may come in my way, my lord.
What limitation?
Because I have not filed an independent appeal.
There is no limitation for writ petition. It's still pending.
No, no,
The
writ-
appointment-
my lord. So what
You can-
happened?
You can make that ground a ground of your writ petition and file it tomorrow, day after tomorrow.
Mr. Sidri, did they file any writ petition? No,
Yes, they filed.
but they, by the common judgment.
Common judgment.
Common judgment.
Common judgment. So they have not preferred appeal. They are also.
My lord, because it is multi.
On this ground, their writ appeal will be allowed. Sorry, their limitation if any will be allowed.
आप अपनी writ appeal file करिए. Don't tie
But-
up with Mr. Chaudhary.
On a lighter note, my lord, the issue has a bearing, my lord. If the Honorable Supreme Court has decided the issue on this ground, then, my lord, the issue is identical. I am not coming in the way of Mr.
I
Chaudhary.
understand in my learned friend's case, there were appointment orders. In spite of that, I suppose appointments were not given. That's why in the contempt petition and order.
Why did you not file an appeal?
No, these are
Lord,
relating to
The
Odisha.
question is
State,
this,
not Assam.
the appointment,
It's a Telangana and all.
my lord, the appointment orders are on the same very course on one document. I'm not trying to delay in any manner.
Is it with respect to 18 months diploma under the orders of the court?
Indeed. Same
And
court.
was there an objection? Was there an objection that these are of doubtful origin, the certification?
Indeed.
No, can't be. Can't be. There can't be so much of similarity in the
I'll put
cases
it on
of teachers,
My lord-
aspirants of two different states. Can't be.
Consider the course is same. The course
Anyway,
is one.
Anyway, we are not in a hurry to dismiss this petition or to modify the judgment of the single judge, which is in favor of the state. State also doesn't have any problem. Mr. Chaudhary wants it to be done immediately. You want that something should be done. We will put up final, decent quietus to the matter. You file your documents.
I'm so grateful.
We'll decide it. Till end.
I'm deeply grateful. My lord, my urge is to assist the court, not to come in the way of anyone, my lord. I must make it very, very clear, my lord.
No, that's
My,
all right.
only to assist the honorable.
We don't consider arguments by counsel to be an impediment in the court disposing of matters. We say so many a times for the paucity of any other expression. We want to cut short any argument which may not be necessary for us to get into. But then lawyers are meant to assist the court, and you have done it. I mean, I don't have any objections to it. We don't feel bad or troubled. In fact, it is always good. Just that we don't want repetition, number one. We don't want off-the-cuff, statements, not backed by records. Just that. Otherwise, we welcome all reasons, all arguments for whichever time.
Certainly.
No difficulty. Now, we would have kept it only day after tomorrow, but for the unavailability of the learned advocate general, who says that he'll be available only in the end of April.
38.
So, what we do is,
28, 38, whatever date is complete.
Let it be 20.
this is your stand.
Our
this-
stand will.
No, so let them file. No, let him be here. You file your affidavit latest. I mean, we'll hear it on 28th of April.
Yes.
Finally.
Very good.
All right. At the instance of an intervenor application.
Like there are 5 applications, my lord. 5 of them.
These are the applications where he is the.
At the instance of interveners,
Dismiss it.
the matter is adjourned 28th of April for final determination. Now I don't think you are required to give your stand. We will take into account there. Let it be there because it has.
I-
I do not know Lord, what type of
Sorry.
arguments will come out, so that may not be recorded today. I don't change my stand.
My lord, I'm sorry.
So that may not be recorded, because if some new arguments come up, then we have to argue, Lord.
All right.
I'm sorry. I've just received instructions on phone from Gauhati, my lord. They are saying that whatever learned Mr. Chaudhary is saying, it can be disposed of in that matter. Let the matter be disposed.
The Lordship, we do
I-
not have to hear some other people's to dispose of the matters. It is not that like that. As your Lordship is taking all the matters together, let a common order be passed and take it.
Now goes with here.
No, he cannot change that his stand from time to time.
अच्छा चलो अभी तो छोड़ दे. Let it
Let it be on 28.
28 April.
No, Mr.
Can I let free a phrase, writ appeal may be filed then in that case? So you
No, I
cannot
think,
have
Lord,
the
let it
cake
be
and eat it too.
today. I'm sorry, the learned is not. I'm saying let it be disposed of today. I've just got instructions that
It is not my happiness which we are concerned. We want the things to go in a proper way.
That's all right. That's all right.
He's a-
But no, we will say that he has
But-
conceded to this, therefore no appeal.
Yes. Very well.
No
Lord, my
appeal.
reserve order.
He has conceded. We have decided his matters in appeal. Let it
My
be
IAS
done.
may- Yes, yes. My IAS may allowed. I will not take the chance of filing a fresh appeal.
You're not taking chances of filing the first appeal. His grievance is met. He has received instructions from Gauhati only. All right. Dispose
Lord,
of-
will-
So the-
Okay,
with
look
that
at
observation that the learned single judge is not interfered with. That's observation.
See, how do we dispose of the petition? We are not interfering.
Lordship is passing
the-
the order separately. Lordship will pass the order today, Miller.
Today only.
Yes, yes.
I will do it. We'll just record certain background facts and say that after arguments, it was agreed upon that whatever documents the appellants have in their possession, that shall be furnished, but it shall be verified by the state. And if those documents which are necessary and which have been filed by other aspirants who have joined service are not available with the record, then they will take a call and intimate to you that your application cannot be accepted. Finished. This is the only observation that we are going to add to the learned single judges.
Whatever deficiency, we will verify from our records.
If you have the records,
Fine.
you want fully trained teachers, you don't want to be in contempt of the Supreme Court judgment in Vishwanath. Agreed. If you don't have, then the presumption would be that they are not bona fide.
Well, our only submission was other than you guys, we are in a position to provide. Other than you guys.
You guys, you check up.
Yes.
If you are finding that you guys is absolutely, because NIOS has given a very, very perfunctory, they have thrown the blame on those school principals who have given the certificate. Now, in that case, you say that these are bad.
Then we'll pass reasoned order.
And give it to everybody.
Yes.
Whoever applies, whichever you're not considering, give it to them.
In fact, NIOS says that if you do not have UDIs, a temporary UDIs could be generated. That is, I put that on in a compilation. That UDIs could be temporarily generated.
Mr. Kalra, it is better that we keep it on 28th. Let it be argued by the Advocate General. Advocate General was, he has some foresight. He understands that you will take this plea.
No, I will not take any plea, my lord. I am resting my case.
No, on 28th, you put it on record.
Otherwise, Milord, we have arrived at a consensus.
No, Mr. Chaudhary, suppose he has argued all this. Tomorrow, without knowing, we'll pass this order. Then there may be question whether this kind of situations was this
he
by the
say that
Supreme
we-
Court or not.
No,
It will
because
be
I am ready
now-
to give my
We stated before the Supreme Court and all that.
Then he will
I'll-
say
I'll
that
give
we
my
have argued
statement.
this was not taken.
Look, I'll give, to avoid that apprehension, I'll give my statement that whatever has been argued by the appellant, we are adopting the arguments. I'll give my statement on instructions, no problem. It can be recorded so that apprehension will not come in the way.
You file an affidavit, you say that this is your argument, but however, what was observed in the court, you agree to it by whatever has been conceived, whatever has been.
Have it tomorrow then.
Huh?
Please, tomorrow I'll file it by today.
File it
Very-
by today, then we.
On 28th, Lord.
On 28th.
28th.
No, 28 will be too long. Sir.
Lord, if we have to go on a different date, then my lord, the
Where is
urgency.
the difficulty? Why do you concede? You file your response, it will come on 28th.
Lord, the reason is this,
For
that
this
every.
case, I was supposed to go to a very important meeting. I have skipped because this matter was partly heard and today the matter was supposed to be closed. And the submission on the last occasion was that they will file the order of the review application along with the petition. That was the submission.
Yes.
That affidavit or that document is still not part of the record. So how they are changing their stance?
I'm
No.
sorry, I'm not changing. I'm not
That is
changing.
why let it be on 28th.
Arguments of
Everything
prejudice
should
may
be on
not.
record and Lordship may pass appropriate.
I will
order.
satisfy every
I am
word.
not, and my commitment is
Arguments
that
of prejudice may not be made, please.
What
But the arguments of prejudice may not be made. I'll satisfy each and every word. I just wanted to close it today because I've got instructions saying that if the matter is being closed, please agree to whatever Mr. Chaudhary has said. I will not back away from any word that I've said and I'll prove it with records
my
and
condition is not ifs and buts.
So you file your affidavit.
And
We'll
if
decide.
my lord would want to segregate, my lords may consider my applications as a writ appeal, may
Now,
detag it.
How can we do that? No, if we
Me-
are disposing
me-
of
me-
the Mr. Kalra, what do you say?
Give me the liberty, my lord.
Independent IAS will not.
Give me the liberty to withdraw these IAs, file an independent writ appeal, and Mr. Chaudhary's matter be decided.
No,
Give me
you
that.
don't require any. If you don't require any liberty, you withdraw this.
Will come in my way, my lord. Limitation will come in my way.
We will say that he withdraws it with the permission of in order to file a fresh appeal. In case it is filed, it shall be considered.
Well,
There's a
limitation
limitation
come in
petition.
my way because the
No,
government
no,
will.
that we cannot say, no. You say, you
The
say that
Limitation Act is very clear. If they are pursuing a different legal remedy,
My lord,
those cases
Mr.
cannot be considered.
Let it come on 20th, my lord. I think there is too much of things that have happened. Let it come on 20th.
You should not have begun this argument.
Look, I
And
will
if you had to make that argument, you had to file that affidavit along with the petition.
I am stating on oath, my lord, I will put that I have applied for the certified copy of the review petition because of some events happening here in the Supreme Court being on leave from tomorrow onwards. We couldn't get it. I have applied it on the same day, within 1 hour of the last hearing.
No, we are not blaming you, Mr.
I'm not
Kala.
running away from anything, my lord.
Don't at this young age you should not get agitated over arguments made in the court. Not at all. Now nobody is blaming you. The court is not blaming you that why did you not keep your promise of filing the documents. That's all right. But then once you have raised this plea, the learned advocate general would be justified in saying that we will decide it on merits. Merits, so far as Mr. Chaudhary is concerned, he agrees to this. With respect to you, he will say whatever he has to say.
Very well.
All right. Let all these, at the instance of the interveners, let these matters come up for final consideration on 28th of April. Okay? Take that. We have heard Mr. Kane Chaudhary, learned senior advocate, for the how many appeals?
We are in one appeal, Miller.
For the appellants in WA number 345 of 2027. And Mr. What is your name? Mandeep.
Mandeep Kalra.
And Mandeep Kalra for the applicants in IA number so and so. And the learned advocate general in all such matters. This writ appeal has been filed by approximately, how many of you? 171.
Yes.
By approximately 171 teachers / appellant who had been working in private, government aided and unaided schools in Assam as on 10th of August 2017. Stop. At that time, 98 teachers. Rest are there. 98. Time, the central government, that is Ministry of Human Resource Development and NCTE, a one-time special 18-month DL-Ed, Diploma in Elementary Education hota hai, DL-Ed, bracket open and distance learning course through NIOS exclusively for untrained in-service teachers so that they could acquire the mandatory qualification under the RTE Act. The appellants were verified by Assam authorities as in service within quotes, in service, enrolled and successfully completed the course by 31st of March 2019. Next paragraph. Sometimes in December 2023, advertisement was issued by the government of Assam for filling up several posts of assistant teachers. The appellants applied using their NIOS DLED degrees. Such special DLED degrees were accepted by the state because of the intervention of the Honorable Supreme Court. But according to the appellants, suddenly and without any purpose, the Directorate of Elementary Education issued a notification on 17th of June 2025 demanding a second round physical verification with a list of documents to be furnished by the applicants. So the primary concern of the appellants and the applicants in the IAs listed with this appeal that such documents, all of such documents cannot be produced, for some of the documents are not in their possession, which could be verified from the state records. Some of the appellants claim that they had a temporary or one-time UDISC code which was later deactivated. It was also their concern that many records were not available in the database because of the systemic problem. Some of the appellants worked at that time in schools which have closed down. Against challenging such notification and the futility of it, writ petition was filed, PC number 3794 of 2025, mounting the charge that such demand of additional documents for verification was arbitrary and in fact violative of Articles 14, 16 and 21 of the Constitution. The writ petition was finally dismissed with costs imposed. The appellants have challenged that judgment and seek to have the notification dated 17/6/2025 quashed and direction to the state to allow them to participate in the examination without any extra documents, and at least keep as many number of posts vacant as are the appellants and the applicants in the IAs listed with the appeals. Initially, several contentions were raised in support of the appeal. That such notification lacked statutory backing, as teachers' qualifications and in-service training fall under the exclusive / occupied field of the union under the RTE Act of 2009, read with NCTE regulations and MHRD letter dated 3/8/2017. Semicolon, such notification, the impugned notification amounted to change in the rules of the game mid-process and practically creating new eligibility conditions. And putting the appellants, teachers from appellants, the teachers from private, unaided and closed schools in an absolutely difficult position as compared to government school teachers. And the illegitimacy and the unnecessity, legitimacy and futility of having a double filter test assess the bona fides of the appellants as participants. The appellants and applicants have in unison submitted that they have a legitimate expectation that with their DLED degree from NIOS, they would be permitted to apply against the advertisement for recruitment and would not be subjected to any further scrutiny. The learned single judge tested such challenge on the anvil of the competence of the state to issue the notification dated 17/6/2025, asking for additional documents for verifying the eligibility criteria. Where those documents demanded by the notification impugned amounted to setting a new benchmark for eligibility, or was it only a verification mechanism? And whether the demand of such documents was impossible to comply with. Stop. Referring to the facts of the case, the learned single judge opined that the impugned notification was only a necessary verification mechanism to implement the NCTE and Supreme Court directions. And it did not in any way create any new eligibility condition. Stop. The insistence on the document, according to the learned single judge, was very reasonable to prevent any fraud. And in the absence of any manifest arbitrariness having been shown by the petitioners, appellants, petitioners/appellants, comma, any interference by the court was unwarranted. Stop. Unwarranted. During the course of argument, Mr. Chaudhary, learned senior advocate representing the appellant, submitted that the appellants would be satisfied if they are permitted to offer the documents listed in the impugned notification, which they are in possession of. And any document which is not possessed by them would be verified by the state from its records. Stop. In case the candidature of the appellants are not found to be genuine and are rejected, comma, they ought to be intimated about the reason for rejecting their application. Stop. Later, Mr. Mandeep Kalra, learned advocate representing the applicants in IA's number so and so, IA number so and so, also adopted the argument of Mr. Chaudhary and agreed proposition that the applicants shall also furnish the documents of which they are in possession of, with an expectation from the state to look into their records for further assessing and verifying their bona fide candidature. And in case of rejecting their application, comma, they shall be informed of the reason. The learned advocate general, though, initially contested the appeal on merits, but agreed that by way of second filter regarding the eligibility condition, especially with respect to the eligibility with regard to 18 months DLED degree, 18 months eligibility degree, which could have been obtained only on a proper certification by the school in which the appellants / applicants were serving. What did I say? And whether such degrees were obtained during the cutoff period, which was permitted under the orders of the Supreme Court, comma, necessary verifications would be made, and in case the application is not found to be genuine, comma, the same shall be rejected with reasons and communicated to the applicants. Correct?
Only thing is that it gives an indication that only regarding their 18 months completion of the degrees to be looked into.
Or the many other things.
Because certification with the support of the contemporaneous record.
They want a clarification.
उसी से होगा, especially लिखा है वो, चल कर दो उसको, verification.
Because the one certificate they have given. They have given certificate.
All right.
You want to verify whether
with the contemporaneous records.
To verify whether they were working within that cutoff date. Actually.
Then certificate along with the other documents.
That is what we have said, that unless you find that they were entitled for this 18 months.
Regarding
NIOS.
entitlement, it is not indicated.
No, it will be clear. क्या लिखा है? फिर से पढ़ो line.
Only regarding completion within that period, that
Okay.
is in addition.
Filter, comma, the applications of the appellants and applicants, वो काट दो वहां से, applications shall be verified and whatever documents demanded, notification dated so and so, is not produced by them, comma, the same shall be verified from the records of the state. And in case their application is not, and in case their applications are not found to be genuine, meeting the eligibility requirement, all its in eligibility requirements as desired, comma, the rejection of their application shall be communicated to them. Communicated to them. Thus, with such undertaking by the appellants / applicants, we consider that this appeal ought to be closed. This appeal and the applications ought to be closed, comma, sustaining the judgment impugned in the present appeal in its entirety, with the only caveat that the applications of the appellants and applicants shall be verified on the basis of the documents furnished by them, and also and if some of the documents demanded by way of the notification dated so and so are not furnished, comma, from the state records, and each of the appellants applicants shall be communicated the reason for rejection of their application.
Just one thing, if I could add, my lord.
In the special facts,
time frame,
in the special facts and circumstances of the case, we also modify the judgment to the extent that we remove the obligation of the appellants and applicants to pay the cost of rupees 10,000, and we make this appeal also cost easy.
Lord, just
time frame, my lord.
नहीं करेंगे. Before,
just two requests, if I could.
just a minute.
3 months time may be given because all will be busy with the election process now.
It is
months.
expected that such exercise shall be concluded within a period of 3 months, keeping in mind that such exercise must be meaningful, comma, meaning thereby that necessary number of vacancies must remain unfilled for such verification to be completed.
Only one line, if it is not required also, if it is found that any fake documents is submitted, then proper action may be taken against the erring person, because the
वो तो आप ऐसे भी करिएगा.
that is not required, but if that.
Why do you want to put that blame against your own officers? ये तो
No,
जाएंगे, जाएंगे.
it is the school principals.
How school? So your teachers, no, your principals, they
No,
are.
no, those are private schools. Those are private schools. Lord.
करिएगा, we do it.
Just two things, if I could add. My lord's permission.
Mr. Advocate General, you people.
I know it is not required.
People
Can
come
always open for
to
us.
the court for relief. We don't want to.
The principals of the private schools are
अरे साहब,
this certificates. These are not from the government
अभी वो
schools.
प्रिंसिपल आएंगे कहेंगे हमको तो सुना नहीं आपने और ऑर्डर कर दिया कि ऐसा होगा तो एक्शन लें, ऐसा नहीं है.
Just two requests.
That is a crime.
He wants to say
Under-
something.
yes.
He
Lord,
wants to
on-
say something. Yes.
Lords have recorded my statement. My lords may consider adding on instructions because that's somehow in the audit.
Mr. So-and-so on instructions from his clients. All right.
And the second thing, my lords have used that phrase that have obtained the degree. My lord, the Honorable Supreme Court says completed. My lord, again a confusion may
Obtained, got out, completed the degree.
be grateful. I'm so grateful, my lords, deeply grateful.
They all such appeals and disclosed.
Now the actual person is NCT.
हाँ ठीक है सबकी appearance लिखा था.
The IAs will have to be allowed and disposed of because of the intervention.
We close everything. We neither
they'll have
allow. We
Allowed
neither
and
dismiss.
disposed of.
Huh?
They'll have to be allowed and disposed of.
Closed and
because-
disposed.
So great.
Don't worry about that, Mr. Kalra. You are arguing before Gauhati High Court. Don't compare it. Don't ask the rules of Delhi High Court here.
Very well.
When we close it, it is disposed. Yes.
Item 32.
Yes.
My lord, we have submitted a written argument. Have come up with one more precise note.
Thank you.
Lord, broadly speaking, I'll be pressing into service 3 points. First, we would like to contend, my lord, that we have a vested right, and that vested right is sought to be denied arbitrarily. Secondly, I'll demonstrate, my lord, how Article 14 is attracted in issuing the impure notifications. In other words, in what manner the discrimination has been caused. And thirdly, my lord, would like to invoke the doctrine of promissory estoppel. These are the 3 broad points on which our argument will revolve. Now, if your lordship should kindly take the note which I have given today, my lord, that will make our job easier, my lord. First, if your lordship should kindly come to page number 96 of the memo of appeal. In fact, at page 94, the Sikkim subject regulation starts. Now, I'll have your lordship's kind attention to
One second.
page 96. One is by birth and other is by naturalization. And our claim falls under the head of naturalization. Therefore, please come to subsection 3 of section 8. The government of His Highness shall also have the power to naturalize a person upon application made therefore in the manner prescribed by the rules, provided that the government of His Highness has satisfied
This is
that.
part of Sikkim Subjects Regulation
Yes,
1960.
yes. The government of the Highness shall also have the power to naturalize a person upon application made therefore in the manner prescribed by the rules, provided that the government of His Highness has satisfied that A, he has been in service of the government of Sikkim for a period of not less than 10 years, immediately preceding the date of his application. B, or he has rendered meritorious service to the state, and person to whom such a certificate is granted shall, on taking oath of allegiance and upon his name being entered in the register of subjects, be naturalized Sikkimese from the date on which the certificate was granted. Now, I may briefly indicate, my lord, respondents number 1 to 15 are the grandchildren of government servant who served the government of Sikkim prior to 31/12/69. That we have indicated in the very first para of our written argument, which I submitted earlier, my lord. And respondents number 16 to 21 are children of government servant who served the government of Sikkim on or before 31/12/69. So that is how our claim rests. Now, my lord, there are rules, my lord. Rules prescribe how this right is to be considered, my lord. Now, that rule is at page 100. In fact, the rule starts at page 99. If your lordship would kindly come to page 100.
Hmm.
5. An application for a certificate of naturalization under section 8 shall be made in the form 6, and an application under section 8.3 with which you are concerned shall be in form 7. Such application shall be made to the Chief Executive Officer. Now 6.2, the Chief Executive Officer may, on being satisfied that he fulfills the conditions for being registered or naturalized as the case may be under regulation, and that the applicant is fit and proper person to be so registered or naturalized, accept his application and issue the necessary certificate for the purpose. The certificate of naturalization shall be in form number 9. Then my lord will kindly come to page 101, my lord. Maintenance of register of Sikkim subjects. May I have your lordship's kind attention to 10.2, my lord. The register shall be kept in form 10 and shall consist of 6 parts. We are not concerned with this, my lord. If your lordship would kindly come to the last 2 sentences. And part 6 shall have the names of the persons naturalized as Sikkim subject under section 8.3 and 8.4 of the regulation. So this is how, my lord, it operates. Then my lord will kindly come to page number 136. I'm placing the statutory provisions, my lord, chronologically, which have relevant bearing in the adjudication of the issue. Now, this is
Sikkim government establishment, okay.
Sikkim Government Establishment Rules 1974. In exercise of the power conferred by proviso to Article 309 of the Constitution of India, the Governor of Sikkim is pleased to adopt the Sikkim Government Establishment Rules 1974 as the rules regarding recruitment and condition of service of persons appointed to the service and post in connection with the affairs of the state of Sikkim, with modification set out herein below, with effect from 26th day of April 1975. Now, my lord, this adoption took place following merger. Initially, it was not. Then, if your lordship would kindly come to page 141. Of 4 on top, rule 4, sub rule 4. Appointment to service under the government shall be by one or both of the methods indicated below, direct recruitment and promotion. Direct recruitment shall include appointment on contract and appointment on deputation. Now, this proviso is important. Provided these 2 types of appointments shall be made, having due regard to the exact nature of the specific duties and responsibilities and the qualification required for the post, and further provided that non-Sikkimese national may be appointed only when suitably qualified and experienced Sikkimese nationals are not available, and replacement of such appointee by suitable Sikkimese candidate may be made as and when available. Lord, this is a law which gives primacy to the locals for the appointment. It is only when, my lord, locals are not available that a non-local may aspire for a job. But the moment a local becomes available, then he will have to make room for the local. Now, my lord, what failed for consideration in Surendra Prasad's case, on which the state made heavy reliance, was, my lord, here, my lord, without the learned single judge of the Sikkim High Court, my lord, without taking note of Article 371F, decided the case saying that it's a pure and simple case of violation of those three, Article 14, 15, and 16. And when the matter traveled to Supreme Court explained the position, because why this is not bad, because 375(1) starts with a non-obstante clause, and that appeared in view of Milord, Article 16(3), this classification can be made. That is the reason. Therefore, Milord, I'll respectfully submit while elaborating, Milord, that Surendra Prasad Sharma is a case where a local was pitted against a non-local. Here we are claiming, what we are staking, Milord, claim of a deemed local. So therefore, these are the two different aspects. Then, Milord, in due course of time, Milord, a merger took place. When this process was on, the merger took place that your lordships will get at page 175. Mm. 178, Milord. And following merger, Milord, the Citizenship Act of 1955 was enforced in the state of Sikkim. Now, I'll have your lordship's kind attention to the two portions below, Milord, bottom of the page, that SO 217E. In exercise of power conferred by Section 7 of the Citizenship Act, the central government hereby makes the following order, namely, this order may be called Sikkim Citizenship Order 1975. Every person who immediately before 26th day of April 1975 was a Sikkim subject under the Sikkim Subject Regulation 1961 shall be deemed to have become citizen of India on that day. And secondly, my lord, this act came to be enforced in the state of Sikkim. Then, my lord, will kindly come to page number 179. Adoption of Sikkim Laws number 1 Order 1975. In exercise of the power conferred by Clause 1 of Article 371F of the Constitution of India, the President hereby makes the following order, namely, the order may be called the Adoption of Sikkimese Laws Order 1975. It shall be deemed to have come into force on 26th day of April 1975. Appointed day is defined. Then, my lord, will kindly come to 2. General Clauses Act 1897 applies for interpretation of this order as it applies for interpretation of a central act. Then, my lord, will kindly come to 4. As from the appointed day, that is 26th day of April of 1975, laws mentioned in the first schedule to this order shall stand repealed. Meaning, page 180, my lord, the 61 regulation stands repealed. However, my lord, by virtue of section 6C of the General Clauses Act, read with article 367, my lord, the right which has accrued or vested, that is saved. That is our argument, my lord, for your lordship's kind consideration. Now, such a right cannot be denied or taken away by any executive instruction, as is sought to be done in the instant case. So, my lord, the position that emerges following adoption, the adaptation of the Sikkim laws is the regulation of 61 stood repeal. At the same time, General Clauses Act was made applicable. The net result, therefore, is the vested and accrued right stands saved. Now, my lord, what had happened, this process of merger and all happened all of a sudden. Then the government of Sikkim realized that there are certain rights which were enjoyed by these people, those are now under some cloud. Therefore, what the government did, my lord, please come to page 185A. On 25th of September 1976, this memorandum was issued by the government of Sikkim. Lord, this is very important for our case, therefore I am placing reliance on it. In order to ascertain the residential qualification of candidates who claim themselves to be local at the time of seeking employment, it has been decided that the candidates should be asked to mention whether their parents' name have been recorded on or before 15/5/75 in the relevant government register. Well, they are not referring to the Sikkim subject register. They are referring to relevant government register. Now, what are the government relevant registers, my lord? One is Sikkim subject register, then electoral roll is there, employment records are there, land records are there.
No. Here I'll I'll stop you here. The word used are parents' name have been recorded on or before 15/5/75 in the relevant government register.
Yes.
Not registers. So therefore, it is referring to the state subject register. Sikkim state subject
No, my
register.
lord, I'll show from the subsequent events.
Because relevant
No, I'll
government
show,
register is
no,
Sikkim.
No, the word, otherwise, my lord, the expression, then they could have said Sikkim
Yes, they
subject
could.
register.
Yeah, you're right.
They
That way,
having not
but we-
said, subsequent events will unfold, my lord, they were referring to other documents also. I'll satisfy.
Okay.
Yes. Then, my lord will kindly come to next page at page number 186. This is a document whereby it is says that domicile or any certificate would be issued by Deputy Commissioner. That is not important. Now, my lord will kindly come to page 187.
Yes.
9th of April 1981. In modification of this department's memorandum dated 25/9/76 and notification dated 28/1/80, that is whereby the Deputy Commissioner was empowered, Governor has been pleased to authorize the district collector within the respective districts to issue certificate to persons identifying them in the following group to enable them to apply for employment in the state. All are these persons? A person whose name is found recorded in the old Sikkim subject register prior to 1975. A person whose name is not found registered in the old Sikkim subject register, but she has established beyond doubt that name of her father, husband, paternal grandfather, brother from the same father has been recorded in the old Sikkim subject register. This too broadly falls in the same category. The person who has agricultural land in rural areas and has been ordinarily residing in the state of Sikkim. A person whose father, husband has been in service of the government on or before 31st of December 1969. So therefore, why I made that submission, my lord, that the intention was not to confine this exercise only to persons whose name finds place in the Sikkim subject register. Their intention is very clear, my lord. Their intention was also to identify the person, these four categories of person. And we fall in the category number 4. Now, my lord, please come to their affidavit, which they have filed before the learned single judge. What I am saying is, what I am submitting is, my lord, would be evident from their stand taken in the affidavit. A single judge have filed to do.
না না আছে রে কোন
না।
পেপার কোড আছে
নাই নাই বাবা
নাই
রিভিজিবল আছে Yes, my lord. I'll refer to the affidavit filed by the state before the learned single judge, my lord. Affidavit, read petition.
তারপর পড়িয়ে না whatever.
My lord, I'll read paragraph 6, 7 and 8. At page 134, 135 and 136. Sorry, page 6, 7 and 8, para 15, 16. Para 15 and 16.
You can read. I'm
Yes.
there concentrating.
After merger of Sikkim as 22nd state in the Union of India, it had become necessary to identify the Sikkim subjects popularly known as Sikkimis or locals, which under the constitutional provision of Article 375(1)(71)(f) was a distinct class of people and who had become the citizen of India on merger of Sikkim. This Sikkim Subject Regulation 1961 had been repealed by the adoption of Sikkim Laws Order 1975. Accordingly, it became necessary and Government of Sikkim wide memorandum dated 25/9/76, whereunder certain category were prescribed to qualify or identify a person as local, that is Sikkimese subject, was issued. The said memorandum is extracted herein below. In May I read it again, Mr.
Yes.
Para 15. After the merger of Sikkim as a 22nd state in the Union of India, it became necessary to identify the Sikkim subjects, popularly known as Sikkimese or locals, which under the constitutional provision of Article 375(1)(f) was a distinct class of people and who had become the citizen of India on merger of Sikkim. The Sikkim Subject Regulation 1961 had been repealed by the adoption of Sikkim Laws Order 1975. Accordingly, it became necessary and Government of Sikkim wide memorandum dated September 25, 1976, wherein certain criteria were prescribed to qualify or identify a person as local, that is Sikkimese or Sikkim subject, was issued. The said memorandum is extracted herein below. In order to ascertain the residential qualification of candidates who claim to be locals, on the view of seeking employment, it has been decided that candidates should be able to maintain whether their parents' name have been recorded on or before 15/5/75 in the relevant government register. Para 16. As per the above memorandum dated 25 September 1976, only those persons whose parents' name had been recorded on or before 15/5/75 in the relevant government register, that is Sikkim subject register, were qualified as Sikkimese or local. The issuance of this memorandum to identify the Sikkimese or local became necessary as Sikkim Subject Regulation had been repealed by the adoption of the Sikkim Laws Order 1975. During the said period, that is 75 to 76, government employment was the only major source of employment. Since Sikkim government establishment rule provided special safeguard for the Sikkimese locals in the government employment, it became necessary to identify such class of people so as to enable them to be eligible for employment in the government of Sikkim. In fact, the said memorandum dated September 25, 1976 clearly mentions the term local, seeking employment and government register. It is therefore humbly submitted that the memorandum dated September 25, 1976 was issued to identify the Sikkim subject, Sikkimese popularly referred to as local, so as to enable them to seek employment in the government of Sikkim
in accordance with Rule 4.4 of the Sikkim Government Establishment Rule. Therefore, my humble understanding is, Milord, what follows from this passage is that even if we construe that it was only for the purpose of employment this exercise was undertaken, but nevertheless, Milord, the category to which we fall was identified as one such category. That means we are eligible to serve the government of Sikkim, or we were eligible to be identified as locals, as Sikkimis. Because, Milord, had it been a case that only the person whose name appear in the Sikkim subject register is to be identified, then, my lord, the language would have been different. So therefore, my humble submission is, my lord, subject to what your lordships may say, that 25/9/76 exercise was undertaken by the state because after merger, all of a sudden everything happened. Therefore, to identify the people to get the benefit of Rule 4.4 of the 74 rules, there was a requirement of identifying. If I am, my lord, otherwise eligible as the fourth category, how can I be denied the other rights, my lord? That is a separate aspect. For the present, I am confining myself to the employment part, my lord. Then I will come to that. So this is how, therefore, my lord, it cannot be said that all the exercise was undertaken only to identify people whose name appeared in the Sikkim subject register. No. That is why the word relevant register, a meaning has to be given, my lord, having regard to this attending facts and circumstances. Then, my lord, this 9481 that I have already placed it, my lord.
State circuit register. Register for the Mr. Chaudhary, we are not able to see any, any light on this. That it talks about other, avenues also, other registers also.
No, now, all of them.
It's very inferential.
Please,
That can be your separate limb of argument, that if you're making such persons local for the purposes of employment, so that they are not replaced by any local, or in the first instance they are picked up, then that would necessarily not mean that they can buy lands also. Well, that's a different argument. You can say that if you can give appointment on the basis of our being local, why can't I acquire property there? Because after all, a distinction, I have been dubbed as a Sikkimese or a local Sikkimese.
End of the day, my effort would be to satisfy your lordship, my lord.
Difficulty is twofold here. That's how, what is passing on in my mind. Now, with the merger and with the Citizenship Act amendment, who is a person there, he becomes a citizen of India. Now you have to see it in this context. Whether this exclusion of yours hits Article 14.
Exactly. I'm coming to that only, Miller. In fact, my effort is to go towards that direction only, Miller. In fact, we have formulated the points when the lordships go through my note which I have given. That is what I am trying to attempt, Miller. Yes. Now, my lord, please come to page 187. 187.
135 paragraphs
yes.
15 and 16.
Now, please come to the fourth category, my lord. A person whose father, husband had been in service of the state government on or before 31st of December 69. That means we were left out. They now they're trying to bring us. When they say, my lord, in that 76 thing, that there are some people who were left out, we were left out in the process. Now they have identified. So having identified, can you mete out this treatment? At the end of the day, my lord, I don't think the state can succeed in establishing that only whose name appeared in Sikkim subject register, they alone are the people who are entitled to certificate of identification or an entry in the Sikkim subject register. We were left out. That's why they have included us. See plot number 1, a person whose name is found recorded in the old Sikkim register. A person whose name is not found, but he has brought some evidence to establish. Person who has agricultural land in the rural areas. Person whose father, husband has been in service of government of India. So even if it is for the purpose of education, my lord, they identified as a group which were eligible. Now subsequently,
you miss out on the main, qualifying line. You don't miss out. You are
for
arguing.
employment.
Huh.
Yes, I'm saying that, my lord. For the present, I made the submission few minutes back, my lord. I said, let us for the present start with the, assumption that this right is confined to this.
That since you have
That's it. I made the submission.
So therefore I said, no, in the beginning, that inference is there that because you treat me as a local for employment,
Why not for other purpose?
not for other purposes.
That's
But look at this.
Yes.
Person whose father, husband had been in service of the state government on or before 31st of December 19. We qualify. So therefore it becomes very transitional.
Yes.
It is for a specific purpose. Now the reason is otherwise they would have said a person by descent. So grandchildren, their children also would come. It says no. Only such person whose father or husband had been in service of the state government on or before 31st of December 1969, thereby, making these persons eligible for being appointed in government service, but not Sikkimis for other collateral purposes. That's otherwise they would not have done this. They would not have. They would have said anybody whose ancestor, father, grandfather, or anybody. Because see, we don't know what was there in the minds, but what is the only rule of interpretation?
To meet this argument, I will rely upon Regulation 8.3 of 61 regulation, which according to us it stands saved. That does not say so, Milord. Please come to that for a moment.
Ajab, you proceed.
Page 98.
You proceed in your own way.
Yes.
You proceed in your own way.
Let me do.
We have told you what is passing on in our mind.
I'll
You
try
will
to
answer
cover.
it later, but you proceed in your own
Correct.
way.
Absolutely fine, my lord. Then, my lord, now therefore.
Actually, this is the argument which is weighed with the learned single judge.
Yes.
And then it has been tested on the annual of Article 14 and 16. See, you have to keep 371F. This is just a tentative view. 371F and the observations in Surinder Sharma. That has to be kept in mind.
Yes. Though in a different context. Yes.
Context was almost similar because it was in the context of employment only.
Yes.
When this establishment rules of 1974, the special provision were upheld.
Yes.
Because otherwise that special provision is absolutely discriminatory. It is because of the special historical importance and the circumstance under which Sikkim was merged as the 22nd state.
Now,
otherwise, who would say that it is not discriminatory?
Now,
if it is to be seen only in the context of everybody being an Indian citizen, including Sikkimis, therefore this citizenship aspect has gone. It's for the purposes
even
of
though
local.
one is a citizen of India, yet he may not enjoy certain rights in Sikkim because of Article 371F. That is why this exercise.
And naturally.
Now,
So
please have my written argument which I have given to them.
If this dominant, objective is kept in mind, then they're classifying it further for employment only and for no other purpose makes quite. It sounds coherent.
Anyway,
apart.
Yes.
What you're saying.
Yes.
Prima facie, what you're stating would be attractive on face of it, because we are used to seeing things in the context of pan-India. You're an Indian citizen. There is no restriction on free flow.
No, my lord.
Things of that kind. Well, that overweighs.
My lord, having due regard to Article 371F, my submissions are so good. Please come to my written argument, my lord. Third page.
The argument that the note that you furnished today.
Yes, my lord. Now, in the context of this 9481 notification, my lord, now I have tried to highlight that, my lord. Somewhere in the middle, persons covered under serial number 2 to 4.
You're asking us to see
Page
which
3, my lord, of the note which I have given today.
Persons.
Have a look at this. Persons covered under serial number 2 to 4 were those who were otherwise eligible for inclusion in the Sikkim subject register under 1961 regulation, but were excluded due to genuine omission as merger happened suddenly and was an unforeseen act. This is our perspective. Now, therefore, what they did,
this is our perspective also, this is the state perspective also.
yes.
No
Then,
difficult.
my lord, what happened? At page 188, they came up with this. There were genuine omissions, therefore, how to get rid of this omission part. 3rd of April 1989, in exercise of the power conferred by Section 7 of the Citizenship Act, the central government hereby makes the following order to amend the Sikkim Citizenship Order 1975. This order may be called Sikkim Citizenship Amendment Order 1989. In Sikkim Citizenship Order 75, to paragraph 2, the following proviso shall be inserted, provided that any person whose name was eligible to be entered in the register maintained under the said regulation, but was not so entered because of any genuine omission, shall be deemed to have become citizen of India on that day, if so determined by the central government.
This is for the purposes of Citizenship Act and Indian citizen.
Yes.
So
Now,
that,
my lord,
see, because of before the merger, it was managed by Chogels.
there is a caveat, my lord. Please come to page 190. 190. Now, who all are the persons, my lord, on which head they fall? Please come to D. Persons holding a regular government job before 26th of April 95, provided that appointment has not been made under the exception clause pertaining to non-subject and his natural descendants. So, my lord, this class of people is also required to be now included
By this committee.
by the committee. Persons holding a regular government job before 26th of April 1975, provided that the appointment has not been made under the exception clause pertaining to non-subject.
So the exception clause is that if Sikkimese is available,
Yes.
it shall go to Sikkimese.
yes.
If not,
If
it will go to others,
Absolutely.
but replaceable.
Yes.
Now,
So, my lord,
therefore, what this is saying is that persons holding a regular government job, meaning thereby that they may have missed out their names.
before 26th of April 1975.
That is the date when the state was created.
Yes.
Now, it was only after that the Citizenship Amendment Act became operative. It was kicked in only for that.
Yes.
Because once it is a part of the state which has merged with India, everybody would become Indian citizen. But we ought not to forget that Sikkim was, the population composition, the demography was not only of Indians from other states,
There also.
from outside also, for local Sikkimese and people, say, from Nepal, from other places, from Burma, many places. So they would not have got the Indian Citizenship Act only because they stayed in Sikkim prior to 75. So therefore, all this distinction.
Correct. But all that I am trying to say is, my lord, amongst other, this category was also eligible to be included.
It was. So it doesn't extend the platform. It only makes it very, very easy for the committee to discern. These are the factors.
Yes.
Suppose you forget your Aadhaar card at the election booth. You'll not be returned by the persons that you don't cast your vote. If you show your driving license also, they'll permit you.
No,
If you
that's
show
true.
anything. So
Yes.
these are the number of things, because insistence on one aspect would make it very difficult. Now, this Citizenship Amendment Act, you have to keep it differently. You have to see it with a different light. I mean, this is again very, very tentative, Mr. Chaudhary. Don't think that I'm arguing against you. We are only saying that we are plainly reading it. Of course, it is very difficult for a non-Sikkimese to accept this situation, being an Indian citizen. Very, very difficult. And transitional phase is for how many years? Or these are questions which are decided under different jurisdiction. Transition doesn't mean for perpetuity. We understand that. So, but that is because we are looking at it from a different perspective, from a perspective of being a non-Sikkimese, from the perspective of being an Indian, of India, of which Sikkim is a part. Why this distinction? If you look at it from that angle, everything would appear skewed. Because what is this? All are Indian citizens. Who can stop them?
No, we were certainly not staking our claim.
वो कैसा करोगी तो आपका ये सब
Staking our claim as a person who have served the government.
all this rhetoric of Assam and Assam for Assamese and Assamese for Assam and everything will go, no? Where does it happen?
That is a larger
because of the historical, evolution of this state, there were loose, it's an artificial construct. Let us talk about Assam. Forget about Sikkim. This again was a very artificial construct. There were so many kingdoms, so many tribes having their own set of rules to govern them. When the Britishers were going, they just, saw a whole picture and said Assam, Northeast Frontier Province. Now, if you look at it from that angle, then what you are clamoring for today, as on date, that will have no ground to hold.
No, my lord.
We find it. Let me tell you, anybody coming away. Anybody coming from outside Assam will find it very, very amusing.
No, my lord.
It's diverse.
In case of Assam, if we digress a little bit, my lord, it's a very peculiar state, my lord.
So is Sikkim.
My lord, Lordship will see, my lord, the parliament itself has recognized that there's a large-scale infiltration. That's why, my lord, I'm just giving an example.
Well, that we will not enter into that discussion. Infiltration, we are not talking.
No.
We are talking about different tribes and groups who deserve protection. Sixth schedule.
Correct.
How does it make a difference? For how long? Transition for how long? But then that is not an argument which is accepted. And that is not an argument which is entertained.
No, my lord. End of the day.
What is the period of transition? Tell us.
If we do not give a power to self-rule, how does this small tribe survive? Therefore.
Apply the same rule here.
No. That I'm doing. And therefore, my lord, I'm within that legal parameters we are claiming the right. For a moment, even what was promised to us by the Sogal, my lord, we're trying to enforce that only. We're not asking for anything else. We're not asking for any mercy from Government of India or in the Sikkim government. All that we are asking for is, this is a legitimate demand of ours. They should accept. There is no difficulty. Now, whether they can confine it to only a particular generation, whether their sons and daughters will get that or not, these are the matters, my lord. At the end of the day, so what I am trying to project is, here is a case.
They allow you to have that identification for the purposes of employment. Cool.
No, my lord.
I think they could.
That's not the thing. Please have the form. Please have this form. When we apply for COI, please have this form, my lord. My lord, this is the application form. Please come to the second page. In the first page only. Come to B. If the applicant applies for COI on the basis of SSC, fill up the following.
What is SSC?
Sikkim Subject Certificate. Then C.
Then SSC's full form is Sikkim
Subject Certificate.
Sikkim Subject Certificate.
Certificate. No? Yes.
Sikkim Register.
Register. Yes.
But C is not, C doesn't.
R would have been register.
C doesn't.
C means certificate, I suppose.
C doesn't stand for register.
My lord,
C doesn't stand for register, COI.
No, Sikkim subject certificate.
Certificate.
Based on that.
Any
register.
person whose name is there in that old register.
We
will be given a certificate.
We were,
Will be given a
we
certificate.
were only demystifying the acronym, just
Yes,
that.
yes.
We understand that.
Then C, my lord, next page. If the applicant applies for COI on the basis of agricultural land in rural areas, fill up. D, if the applicant applies for COI on the basis of Indian citizenship certificate. E, if the applicant applies for COI on the basis of regular government employment on or before 31st of December 1969, fill up the details.
So this is only in continuation and in obedience to the government notifications that you read. 1976, 1980, 1991.
No, my lord, what I am trying to
Because
submit.
these are different markers.
And categories.
These the markers you identify this or this or this. Not necessary. It doesn't say that cumulatively you should have all.
No, my lord, all that.
Suppose nobody was in service. Your father, your husband were not in service. You want this for employment because you're the son who took birth.
No, my lord.
Correct. So then you can trace it with your land, lineage.
No, my lord. So therefore, if somebody's parents have worked under the government, they're also a class who can apply.
Oh,
We
hey,
fall in that category.
No, where has it been refused?
If the applicant applies, no, they're refusing, they're not accepting our applications.
That's
No, no, that's the whole thing.
That's not the subject matter, my lord.
Why
That's
this
not
is
the
not
least
sub-
before.
Yesterday, just a minute, let me understand. But that
Lord, I cannot take admission in educational institution because COI is not there.
no. Certificate.
Let the government clarify that we are getting it.
We will not, because this is not the lease all about. You file a writ petition, will come up.
What you file a writ petition?
This
The
is
writ
not the writ
petition is
petition.
what about? We have challenged the validity of the notifications, where you have confined it to a particular limb of argument.
No, it is only for this that certificate of
No,
identification is.
Lord, I have placed
For
it
other
to
things, that's all right. It's all right. No, it is very, very discriminatory if seen from an Indian context. We understand that, Mr. Chaudhary. Who disputes it? Who disputes it? The difficulty here is with respect to employment and other things. 371F.
No, my lord.
How do we forget that?
No, my lord.
Has the transition period, has it been repealed from the Constitution? 371F.
It's still there.
Then
No, what I am trying to submit is, now for a moment, your lordships will kindly come to page number 96.
For employment, your entire size is for employment. Are you asking the court to adjudicate that if you obtain a certificate of identification for the purposes of employment, because here you have no difficulty. You have no difficulty if your father, husband, otherwise land, purchase, anything on or before the cutoff date, you become entitled to be considered for employment. Correct. So you want this employment certificate, this identification to be used for other purposes also,
Yes.
like Aadhaar card. वो तो बड़ा मुश्किल है ना. That is the government domain, very difficult.
Memo 2010, right?
मुश्किल है. With a ration card in your name,
No.
you can't enter the lounge of an airport.
No, my lord. Now please come to 96 for a moment. I'll elaborate my argument. Now my claim rests on this statutory provision.
Page 96 of the
Yes,
brief.
yes, that's the part of the regulation. A and B. He has been in the service of the government of Sikkim for a period of not less than 10 years, immediately preceding the date of his application, or he has rendered meritorious service to the state, and the person to whom such a certificate is granted shall, on taking oath of allegiance and upon his name being entered in the register of subject, be naturalized subject.
Now it is to be seen in this context. Now look at this. Now please hear out dispassionately, not the brief that you're holding. Now this 61 stands repealed. You are advancing the argument on the presumption that this is saved because of the
Saved,
General Clauses
yes.
Act, because concluded transaction. In that context, if you see, there is a further effort of the government of Sikkim today to have you included and taken on board, because there could be myriad circumstances when you would have not been, identified as
Or
one for the
included.
purpose of employment. So it is only giving you an extended opportunity of proving that you also could apply for employment. Correct. So you don't read this now. This for concluded thing. You refer to 1961, not for new aspects.
For a concluded.
For a concluded one. Conclude to one, because it was not in the register.
No, Lord, what has not concluded is eventual act, but the right of consideration subsists.
Who is stopping it? Right of
That
consideration.
they're denying, my Lord.
No.
Otherwise, why they have come up with this notification?
They have come up with this notification for the reason of precluding people of using the certificate of identification for purchasing property, for owning property, or transfer of land.
We have properties, my Lord.
You
We are
may be
having,
having, you may
and
be having.
after the 81 OM, my Lord, this was used for practically for all
Or
purpose.
that certificate would not get you the largest which the government of Sikkim would do for the Sikkimis.
No, my Lord.
बड़ा मुश्किल है ना.
No,
Employment,
my Lord.
are they? We see it in a positive. I'm repeating. If I see it from an Indian context, I find it to be very, very discriminatory. What is all this? Any citizen has free access to everything. But that is not the way in which the law ordains us to think. No. The law ordains us to think it in a different context. The transition period appears to be unending. We can't help it. We can't help it. Let us admit it. So in this context, the mandate, I would not go beyond the mandate of Article 226, no. Now, can I go beyond?
No, my Lord. Assuming Lordship is not testing from the perspective of an Indian citizen, assuming your Lordship is examined from the perspective of a deemed local.
And not only this, you have not heard the whole of formulation. Now, this 61 regulation, you keep it on the shelf. Let it gather dust now. It is repealed. Now, you have to see everything in the context of 1974 establishment rules, which has been adopted, and the provisions contained therein, Section 4, if I remember.
And they say, my Lord, to give the benefit of 4.4, they have undertaken this exercise.
So this is only for employment.
Yes, employment. They say.
If they renege from this an inch, we'll stop them.
No, Lordship will kindly.
We'll stop them. We will issue directions.
No, my Lord. I'll show one more aspect. Please come to this note which I have given, my Lord. Please come to page 4 of that note. Page 3 was the bottom.
We understand you have to climb uphill.
Yes.
I understand.
Yes.
So ये सब बहस नहीं करेंगे तो बहस कैसे होगी? You have to formulate. Don't think that we are stopping you at every minute.
Certainly not. Please come to, my Lord. Notificate 12. Notification dated.
और ऐसे आप देखिए, just a little digression for a second. Covered matter. It is no great fun to argue covered matters. तो ये तो बढ़िया है ना, ये आप you are arguing this, we are only giving you our posers.
Correct.
I don't take it as an interjection.
No, certainly not.
Because
what we are
normally
trying to say,
I'm normally apprehensive of this, that advocates think that I stop them from arguing. No. This is you're making
get the mind of the court, then it becomes difficult for us also.
You have undertaken an uphill journey. If you have taken an uphill journey, तो हैगा ना, कार ऊपर से आती है, right of way आपको देंगे, लेकिन you're traveling up, we'll give you right of way, लेकिन हम नदी तीस्ता में तो नहीं गिर जाएंगे ना. I will also have my own way, no? I'll not fall in river Tista.
Yes. Please come to page 3, my Lord. That regarding notification dated 22/11/95 at page 195. Please have that notification first, my Lord.
Page
195.
Same issue is with Nagaland.
No, Nagaland is on a slightly, my Lord.
Principles are the same.
Nagaland indigenous and indigenous.
Nagaland, my lord, the first matter,
Let's see.
in supersession of the memorandum dated September
It is
25,
at page.
page 195, my lord. This notification is also under challenge, which was interfered with by the learned single judge. In supersession of the memorandum dated 25/9/76, notification dated 28/1/80, 9/4/81, and 17/3/87 of the state government is hereby pleased to authorize district collector, subdivisional officer, and revenue officer within their respective jurisdiction to issue certificate of identification to person falling in different categories as indicated below on the recommendation of Gram Panchayat, and on being duly satisfied that such recommendation, with such satisfied with such recommendation, a person whose name is found recorded in the old Sikkim register, a person whose name is not found in the register of the old Sikkim, but my lord, he has been able to brought out things. Then a person who has agricultural land, a person who is holder of a citizenship certificate issued by the district collector under so-and-so order and 89 order, a person whose father, husband has been in Sikkim government service on or before 31/12/69, certificate or identification obtained by such person shall be for the purpose of employment only. Now here again, my lord, they are creating a fifth class, whereby, my lord, rather earlier we were in fourth category, now we are in 5. Here also they are confining the COI's, operation to, my lord, only employment aspect, not beyond that. Now please have the written argument, my lord.
यहाँ ये बहस कर सकते हैं कि ये सर्टिफिकेट ऑफ आइडेंटिफिकेशन, ये जो 4 लोग हैं, इनको हम देंगे फॉर अदर पर्पसेस और इसको हम देंगे केवल फॉर एम्प्लॉयमेंट। ये बहस कर सकते हैं। I think people coming in category 1, 2, 3, and 4 also.
Yes.
For them also, this certificate is only for employment. If you could have argued,
yes,
that a certificate of identification with respect to persons who apply for it on the basis of entry in 1 or 2 or 3 or 4,
yes,
can use it for different purposes, but under 5 it
we
can
are
only,
okay employment.
but ये नहीं है. All 1, 2, 3, 4, and 5 all are for employment only.
Because it refers the earlier notification. उसमें तो employment के लिए था certificate.
Only 5 is for employment.
नहीं सर, आप देखिए ऐसा है, the last line in item number 5 that starts as a new sentence after 69, after 69, 31/12/1969, stop, period. Then says certificate of identification obtained by such persons. Now such persons are not only persons in category 5, but persons shall be for the purpose of employment only. And this you get it confirmed by the supersession of memorandum of 1976, which was for employment. So by this, what we are seeing is this. We have applied the glasses with correct power.
No, subject to correction.
Just a minute. It says, now, what is 1976 memorandum?
Remember, 1976 memorandum, my lord, after Sikkim was carved out, my lord, that was issued. That is at page number.
It is only an extended opportunity to such children of government servants under Chogyal. Otherwise, they would have used the cutoff date to be 75 and not 69.
No, my lord. Our instruction specifically is, my lord, 1 to 4, they are getting it for all purpose. It is only the 5th category.
You have to show this. It is meant for this only. It is meant for employment only.
No, my lord.
It must be overlapping with other requirements for other registers.
No, my lord.
These may be overlapping for other requirements under other registers.
No, my lord.
But you can't truncate it. We don't see any
no, my lord.
demarcating line.
I think, my lord, I think, my lord, our instruction is very clear. The 1 to 4, they are getting for all purpose.
My lord, no averment to the effect in the writ petition, that's not the issue.
No. Please don't take that
My lord,
stand.
I will take it, but
Mr. Day, we do not appreciate that stand. When we are discussing the matter, when we are looking at aspects with 371F in our mind, we ought to know. Because one part of his argument would be, they may not have said that, but today during the course of argument, if this idea erupts, we need to clarify ourselves. No, don't take that hardliner stance. It has
no, I yet
doctrine
had a
of
second,
non-reverse and this and that.
I
No.
yet had a second sentence.
Hmm?
I yet had a second sentence for your lordship.
Yes.
Right from 76 till 2000, our consistent stand, and as we look at it, my lord, I'll use your lordship's words with correct power. Any and every category from 1, 2, 3, 4, 5. End result is COI. And COI is only for the purpose of employment and employment
We
only,
have followed. We have followed. Now,
which is written.
now with the statement having been made by Mr. Chaudhary 5 seconds before, that people getting this certification in category 1, 2, 3, 4 are using the certification for ration
purpose.
for all purpose. Is it correct or not?
It is not correct.
बस यही करो. Factually incorrect.
Lord, our instruction is they are getting everything.
तो क्या कहें? It is your instruction vis-a-vis his instruction. And now I ask for the decision in this case would not hinge on this.
Kindly give me 1 minute, Lord. Let me check my writ petition. I'm sure there are amendments. So writ petition can be. Kindly give me.
You're raising this point, you would have really raised it. देखिए. You'll have some breather if that goes non-traversed.
Without really interrupting, your lordship will see the dates of the notifications. 76, 81, then there is a big lull. Nothing. Next is 95. Why? Surendra Prasad. Surendra Prasad came in somewhere around April 94, my lord. Thereafter, my lord, all these things, COI. So, my lord, it was categorized. Right in 76, it was written that it is for the purpose of employment only. Son, grandchildren out. Now, my lord,
If that is the case, then I think, Mr. Chaudhary, it is an extended opportunity to people who could not climb on the bandwagon.
that's it. As in the case of citizenship also.
इंडियन आई से देख ली अच्छी इंडियन आई से दी ये सब क्या है हम कम ही स्टेट still get this money because they are applying that we are also left for what is ongoing. Their application is pending. 33,000 now. So 40,000 हो गया. तो इसको अगर अंदर कर देगा तो उसको सीओ नहीं से रजिस्टर में एंट्री हो गया, नाम आ गया. क्यों
नहीं तो उसके बेसिस पे फिर सीओआई मिल जाएगा.
हाँ, not सीओआई उसको होने से बाकी काम में उसको काम आएगा. Basically दो इसमें
Option for you. And
Lord, I intend to file an affidavit on this point, Lord, because our clients are very clear, my lord, that the others are getting all the benefit and will come up with materials.
But
I'm sorry to make that submission at this middle of the argument, my
नहीं,
lord,
that's
but
right.
considering the importance
That's
of the
right.
matter.
But just a minute. But yeah, this even if you're able to demonstrate it,
Yes.
and he does not reverse it, this this proceeding would not hinge. I mean, the result would not hinge on that.
In which case, lordship will have to remand the matter to the learned single judge.
No, in that sense.
नहीं अभी तो वो क्यों? Why will I pull in that fact?
No, my
There's
lord.
an appeal.
No, my lord, it's a continuation.
All
of-
right, we don't go by such
No,
hard.
Our High Court has good judgment on that point, my lord.
You know,
That we can, my lord, that part I can overcome.
it all depends. I mean, when if we don't have to
Yes.
consider this, if we have to shut our eyes, we'll say that you have not done it. Otherwise, we always 226 key extension, we can always take it. Yeah.
Yeah, amendment taken specifically in mind. মানে প্রবলেম কি হয়েছে বলছো ইংলিশ টাইপের কিছু সব বানাই তো আমার স্টেটমেন্ট লিখলে ওই কথা তখন প্রবলেম হয়েছে কি সব ইংলিশ টাইপ
That argument has
আমার
been
না থাকবে
taken by single judge. Who says it to me?
Yes, sir. তাহলে এটা আপনি ফাইল করবে লিখবো আমরা।
जरूरी है इसको तो अगर affidavit file करेगा तो you'll have to respond. If you file that affidavit, Mr. Day, you'll have to respond.
Yes, my lord, I will, but at the same time, my lord, I may just humbly submit. Is this the forum where they make it?
No.
Of course.
But then question is, see, Mr. Day, today we are not living in those yesteryears. We have moved ahead, 75 years have passed.
Yes, yes.
We are exercising our powers under Article 226 in an extended in the appellate form, correct? Now, the developed nation, role of judiciary, day in, day out, you remind us. We pat our own back that from agrarian reforms to digital India, we are behind the scene. No matter how much criticism and opprobrium you put us to. But then, can we shut our eyes to this?
Never.
Never. So therefore, if he says that people, this argument, of course, if you apply that technicality, maybe we will not permit him to argue this case. But it makes great sense when people, ultimately they are all Indian citizens. Even a Sikkimese local is an Indian citizen.
Yes, absolutely.
Correct. So for that aspect, that he should not be discriminated vis-a-vis others, because if somebody, a person who had agricultural land, he may not be local Sikkimese, but because his grandfather may have purchased land and he continues, that has been bequeathed to him.
No, there the matter.
Just
is
a minute.
completely
So
different.
if you allow the certificate of identification of a person who enters the bandwagon under category 3 and don't allow it for 5, then of course he can argue Article 14.
Discrimination. That's per se discrimination.
Therefore, I'm saying that offends Article 14.
That is not their case, my lord.
Therefore, you deny this, na?
My lord,
This may not be their case.
if there is an affirmation on record, we will deny it. And my lord, for space, my lord, let me tell one more thing. What, in spite of there being 76 and 81 notification, what demanded reissue of the same tenet in different language in a broader form in 95? There must have been abuse. There must have been abuse. So the process is to stop the abuse, my lord. And abuse doesn't institutionalize the violation. The violation cannot become the law.
You did not find, my brother has found it. It has been pleaded in your petition.
Yes. Paragraph, I'm sorry.
X-ray eyes hai. तो कहाँ से देख?
Paragraph.
Page 23 of
Writ petition.
writ petition.
5.8, I think, file.
5.8.
अब आपने तो कहा नहीं है. इनकी नजर से कुछ बच नहीं सकता है.
And we'll see what is our reply, my lord. I have to copy that.
And your reply on this?
No,
Milord,
let me clarify one thing, Milord. I'm obliged to my lord, Milord. 5 point is a statement that following 9481, when COI was issued to us, we were allowed to avail all the benefit.
Yeah.
Subsequently, no. So it is not an positive averment that the other categories of persons are getting, we are not getting. Kindly have a look at that.
Statement on the basis of knowledge है या disclosure है? इनकी affidavit देखिए.
You are right.
Here there is no
Knowledge.
all knowledge. All based on your knowledge. That is what affidavit says.
No, Milord, I think we'll have to come with farmer statement, Milord. That statement, that 5.8, what we have said is, Milord, on the strength of
Therefore-
9481.
That's fair.
Yes.
That's fair on it. They follow.
There is a reply, a very categorical reply for the state to that.
What is it?
Para 43 of our affidavit in open sheet.
पढ़िए.
That with reference to para 5.8, it is vehemently denied and disputed that memorandum dated 9/4/1981, annexure P7, was accepted by the respondent for all existing purposes, namely as proof of one's domicile, resident of Sikkim, for selling and buying of immovable property in Sikkim, employment of the government of Sikkim, education, scholarship, for obtaining scheduled caste, scheduled tribe certificate, and other caste certificates,
Okay,
etc.
we have followed, you have traversed it.
Therefore, my lord,
No,
that
no, no.
statement is imperative.
No, therefore, this is an oath, another oath.
No, my lord, what I am saying
But I am
is-
telling you this.
Yes.
Think of that, conceive of that situation. These people may have got other rights.
No, my lord.
But
Our
this
case
is
is
overlap.
slightly different, my lord. In para 5.8, all that we have said was, following 9481, we were enjoying all the rights, including right to land, etc.
That is what he said.
No, no. He
Thereafter-
says no. But the query is not that. Query
Please.
is whether 1 to 4
are getting
are
other rights.
getting yes.
So that is what he said.
No, that is, how can he reply? Because
Just
that
a
is not
minute.
even posed.
I'm going back to his argument. He
Yes.
says that 1976, 1981, then 1995, it was all post-surrender.
Post surrender.
Post-surrender. So this is his answer. Post-surrender, they say that no, 371F, you please follow. You please follow the establishment rules of 1974. 74, no?
74.
74, even though it is prior to the merger. So
Because it was adopted.
because it has, that's what I'm saying. 61 was also prior, but it has been deleted. Concluded transactions will be saved because it doesn't say so, but there is no saving clause, but the general clauses.
General clauses was
General
made
clauses.
applicable, therefore that consequences will follow.
Correct, correct. So now this statement, that statement.
I think,
is
Lord,
little-
the statement which.
You can make a statement.
Yes. Would like to make that.
But
Let us see, my lord.
बताइए rest bahas complete हो.
हाँ. Rest, I would like, Lordship like to complete it.
इसको खत्म कर दीजिए. We will.
Yes, I'll do that. But I would like to file that affidavit, my lord.
Please, we will allow that.
Or if your Lordship kindly grants us 1 week time, my lord, before Bihu only, my lord, another 15 minutes I'll take after the affidavit, my lord.
By watch, if you take 15 minutes, then we have nothing to say.
Yes.
Of course,
I'll
we
do
might
15
ask you
minutes.
to take 20 minutes to remind us of what we are.
Yes,
what
yes.
we
I
are.
have actually concluded, my lord. Only point I have to argue is, my lord, promissory estoppel point. There was a promise. That promise has been broken.
No, that argument, if you get this space to argue this only then. Where is the promise?
The promise, my lord, the regulation, Chogal's thing.
No, that is repealed. Where is the promise?
No, the promise is, no, my lord, that promise is.
Rather, the promise of Union of India was that you shall be protected under 371.
We had a vested right to be considered. That consideration has been denied.
You have to reframe it. There is no vested right here. There is no promise here. On the contrary, the promise is of the Union of India under the Constitution.
Served 10 years before a particular date, they are entitled to, my lord,
She's saying
COI.
something. Please hear her out. We get something that she's saying something.
My lord, actually, under this Hogal regime, my lord, more than, my lord, residents, more importance was given to person who served this Hogal. That's why, my lord, this category was.
That is why in the beginning, before 1960, in 1961 only, they said, please.
No, my lord, if I had a subsisting right to be considered, now will the effect of 6C would not be that I still have a right of consideration? Well, my lord, that's the point which I would like to make for Lordship's kind consideration.
You can take up that point on the next date, but I don't think it has a lot of strength.
Is it that, my lord, only concluded?
Where is the vested right? Come to 61.
Yes.
Where is that vested right?
Yes.
I don't think so.
Yes, my lord, 96.
Page?
96. The 8.3, my lord. The government of His Holiness shall also have the power to naturalize a person upon application made therefore in the manner prescribed by the rules, provided that the government or His Highness are satisfied that he has been in the service of the government of the Sikkim for a period of not less than 10 years immediately preceding the date of his application.
You come in which category, A or B?
My lord, A.
And then you being the descendant, you being the child or the grandchild of such person, Where is that?
No, my lord, we are only government servant.
Only government, sir.
Yes.
Where
I
is
have
the-
served
Then
government.
where is the promise now? Where is the vested interest now?
No, my lord, our applications are pending. We
So
applied.
that will be decided.
Our
Why clamor?
applications are pending.
So that application is pending one.
18,000 applications are pending within which we lie, my lord.
All right, 33,000 have been
No,
disposed of.
74 has been
74 have been
considered.
disposed of. So therefore the clamor should be for other thing, for disposal of that application.
Yes.
Not for questioning the modification in the.
No, my lord, I have to show, my lord, how my right has been infringed, why I am entitled to
Let you
consideration.
process it here on these grounds. Can we question the
My
state?
lord, kindly give me a short time, my lord.
We
I'm
will,
going to
we will give.
File an affidavit.
File
Short
an affidavit. We'll
Mr. Chaudhary, suppose, just for my clarification, suppose your name is on the basis of that application is inserted in the seeking subject registered
Yes,
now,
yes.
then what? Then you are entitled for everything.
Everything.
So let it, you pursue that. Then why are you pressing this? Let it remain.
Oh, look, we are not pursuing. We have got a judgment in our favor. We're trying to
No,
defend
that
the
judgment I told you. Isko off karo to. Put it.